Good evening, folks. Our new Wednesday night with our new show. This is Night Court revisited. Really, we used to do spaces called Night Court, but we're going to do a stream called Night Court. This show's a little different than the grand jury. We're going to show you a criminal trial. We're going to show you a real criminal trial with real defendants, real witnesses in a real courtroom, and using real law. This one in particular comes out of the state of Texas. But we're going to show you just what the jury sees. I've edited it. I've only shown there's no sidebars, no commentary from some news commenter. There's nobody in the hallway that's giving their opinion on this. You are sequestered as the viewer, like the juror is. I'm only going to show you what's called in camera, in front of the jury. All the testimony that the jury heard, all the instructions that the jury received, all the evidence that the jury saw to make their decision. Folks, it's going to take us 4 weeks to get this through, doing an hour each week on Wednesday, same time as we do now. We're just taking the place of our interrogation slot. On the fifth week, we're going to bring in our jurors. All of our jurors this week are our Patreon paid tier, our support members in Patreon. They will be our jurors. We've got a couple of them watching backstage tonight for this first episode. We'll bring all of them in like they do on Survivor, and we're going to hear their deliberations. Once they've deliberated and our mock jury has given their decision from the evidence that they saw, which is exactly the same evidence that the jury saw, we're going to reveal the real jury's decision and the consequences or no consequences as a result of that jury's decision. But Big Ron, I know it's a lot of moving parts. You're still our producer on this show, but what do you think about the concept?
I'll tell you, Joe, I'm really excited about this concept. I think it's going to work out really well. I think the people out there are going to enjoy it. Hopefully we can keep them captivated. But yeah, I'm still in the back pushing the buttons, making sure everything's running the way it should. Keep an eye on the chat. We got our buddy Mayhem out there in the YouTube world, making sure everything's covered there. So I'm looking forward to this, Joe. I'm really excited.
Well, good deal. We're going to get to the video in just a moment. Tonight's show's going to be roughly just under 1 hour. The way the witnesses break up in this, I didn't want to get in the middle of a witness and kill it, and you come pick up on a and have to remember what the beginning part of a witness's testimony was. But we will get through the exact first witness, the reading of the indictment. We're going to hear the defendant's plea, and we're going to hear the state's opening arguments, and we'll hear the defense. Actually, in this case, the defense declined to make an opening argument. But if they had made they had the opportunity to make one, we would have heard it. But we won't hear it in this case. The defense felt it was the best tactic not to give an opening argument. This is going to be the offense of a short barrel firearm, a prohibited firearm in the state of Texas. We're talking about a sawed-off shotgun that a citizen was found in possession of, and the state is prosecuting him for possession of said firearm. Without doing too much more, folks, give us a like, give us a share, give us a subscribe. Let's push this out there on our X feed and see if we can't get some fresh eyes on this. This is our new show. Let's get into some testimony.
All right, good morning. Good afternoon, ladies and gentlemen of the jury. Rarely do I say that because usually we get started in the morning. We are now on record cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. And as I told you yesterday, what we would do this morning is we would present the indictment to the defendant, and then we'll begin with opening statements and the first witness. So at this time, if Mr. Young, if you'll please rise. Mr. Hartwell, if you will present the indictment to Mr. Young.
In the name and by the authority of the state of Texas, the grand jury for the county of Van Zandt, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2021 of the 294th Judicial District Court for said county, upon their oaths present in and to said court at said term that Reginald Hoyt Young II, hereinafter styled defendant, on or about November 25th, 2020, and before the presentment of this indictment in the county and state aforesaid, did then and there, intentionally or knowingly, possess a short barrel firearm, to wit, an Eastern Arms 16 gauge shotgun, against the peace and dignity of the state, signed foreman of the grand jury.
Thank you, Mr. Hartwell. And Mr. Young, how do you enter a plea?
Not guilty.
Not guilty? All right, thank you. You may be seated.
May it please support Mr. Stevens. Good afternoon, ladies and gentlemen. Been practicing that one all day. I want to thank you all for returning today. I know there's a lot going on right now. I know there's a lot happening in your lives. So we truly appreciate your time and dedication to seeing that the justice system has the opportunity to work. To be really kind of blunt about this case, it's fairly straightforward. On November 25th, you'll hear evidence that deputies with Smith County Sheriff's Office was investigating another incident that happened in Smith County. You'll hear that Mr. Young was not the subject of that investigation. In fact, the subject of that investigation was a man by the name of Russell Melton. However, during the course of their investigation, the deputies with Smith County were led to the property that Mr. Young resided on. You'll hear that they found some evidence from that Smith County incident on the property. And as follow-up, they got a search warrant and searched the property, where they found a sawed-off shotgun. You'll hear evidence that Mr. Young admitted that he in fact did have possession of that sawed-off shotgun. Ladies and gentlemen, by the end of the trial today, tomorrow, we expect that the evidence is going to show that in fact on the property in Van Zandt County, where Mr. Young was staying, there was a prohibited weapon, 16-gauge shotgun that was sawed off. And I believe the evidence is going to show to you that Mr. Young was in possession of that shotgun. At the end of this trial, we're going to ask you to find Mr. Young guilty of this offense. Thank you.
All right, before we get to the first witness, I want to make a point. Something that, we do the grand jury on Friday nights, folks. The indictment that you read is the product of a grand jury that listened to the evidence the state presented and decided that there was enough probable cause for this citizen to bear the weight of a prosecution. This is the result of a true bill that we see on Friday nights. Then when folks decide that, this is what happens to it. So we had the reading of the indictment, and that's the official charge. And those are the elements that the state is required to prove to a jury. It was read to the jury, so the jury understands what the indictment is now. They've heard the plea of the defendant. He says that he is not guilty, and he wants his due process, which is a jury of his peers hearing this case. So now we're getting to the first witness. This is a Smith County deputy. That a quick scenario on this, just so you can follow, because it doesn't really come together real well, in my opinion. This is a result of an investigation in one county, Smith County, in the state of Texas, that resulted in Van Zandt County, a neighboring county over. They're investigating a burglary, a house burglary, where there was some high dollar items like gold and gold coins taken. They got information, run down a suspect they were looking for. They were looking for a vehicle this guy was driving, and they find it they got information that it was in Van Zandt County. They go there, they find that it was in Van Zandt County. They make a contact, write a warrant, notify Van Zandt County Sheriff's Office of their actions going on there. So at that point, it became two agencies working together on this. But this all stimulated out of a burglary offense out of Smith County that took the investigation into Van Zandt County, and that's where this trial is being held right now. So let's go to our first witness.
Good afternoon, Investigator McDonald. Can you please start by introducing yourself to the jury and spell your last name for the court reporter?
Absolutely. Tim McDonald, TIM-McDonald. And I'm Tim McDonald, an investigator with Smith County Sheriff's Office.
And Investigator McDonald, how long have you been an investigator with Smith County?
Right at about 10 years.
And has that been continuous?
Yes, it has.
So you would have been an investigator with Smith County in 2020?
That's correct.
Did you have any other law enforcement jobs or roles other than investigator with Smith County?
I did. I was a patrol deputy for approximately a year and a half prior to becoming an investigator.
And can you tell me a little bit about how you become a deputy?
Absolutely. Initially, it began with Police Academy. I was a patrol deputy for Smith County Sheriff's Office, and I was promoted to the Criminal Investigation Division in somewhere around November of 2017.
And Investigator McDonald, I want to take you back to November 25th of 2020. Do you recall that date?
I do.
Were you on duty on that day?
Yes, I was.
What was the function of your job that day?
I was a criminal investigator.
And were you conducting any kind of an investigation?
Yes, I was.
Without going into too much extraneous detail, can you tell me what the basics of that investigation was?
Yes, we were investigating a burglary that took place in Smith County.
And was the subject of that investigation an individual by the name of Russell Melton?
Yes, it was.
At some point, did your investigation lead here to Van Zandt County?
Yes, it did.
Where in Van Zandt County did your investigation lead to?
Is it okay if I reference my report for the address?
Would referencing your report refresh your recollection?
Yes, it would.
Go ahead.
We went to multiple addresses on or around VZ County Road 4909 and 4910.
And at some point, where was the end point of the Van Zandt County part of that investigation?
For me, it was at on 4910.
And who lived at that address?
I know that Reginald Young lived there, and there was a female that I believe lived there as well. I cannot recall her name.
And at that address, was that the address that you went to, was that in Van Zandt County in 2020?
Yes.
And you mentioned a Reginald Young lived there. Do you see him in the courtroom today?
I do.
Can you please describe what he is wearing and where he is seated?
He's seated at the table there, and he's wearing a light blue shirt.
Your Honor, may the record reflect this witness has identified the defendant as Reginald Young?
The record will reflect that this witness has identified the defendant in this case, Reginald Hoyt Young II.
And when you got to that property, what was it that captured your attention there?
There was a vehicle there that we were searching for that belonged to a Michael Ward, I believe his name was, and we came upon it. So that's what brought us to that location.
And at some point, did you find Michael Ward?
Yes, we did.
And did you also see Mr. Young there?
Yes, we did.
Can you tell me a little bit about how the case developed upon arrival?
We were able to locate some of the evidence directly related to our burglary in Smith County on that property.
As a result of finding some of that evidence, what was the next step that you took?
The next step was to generate a search warrant for the property to search for more evidence in our burglary that occurred in Smith County.
And can you kind of describe that property for me, like buildings, vehicles, things like that?
Yes, there was on that property, there was a mobile home. There was an RV parked and set up very close to the motorhome or the mobile home. There was a Mustang that we already discussed, and there was also an orange, I'd say a mid-sized SUV, Dodge Nitro.
And were you able to determine, you said a mobile home and an RV, were you able to determine who lived in what area?
Yes, we did.
And were you able to determine where Mr. Young lived?
Yes, we did.
Where did he live?
Mr. Young lived in the RV that was next to the mobile home.
And throughout this process, did you ever notify Van Zant County law enforcement?
Yes, as a common courtesy, we did.
And what was their response to being notified?
They arrived on scene shortly thereafter.
And you mentioned earlier that you got a search warrant put together. Were you able to execute that search warrant?
Yes, we were.
What was found as a result of the search warrant?
We located a firearm that was found to be a violation of Texas law.
And Investigator McDonald, do you recall what happened with the firearm that you found?
I do not.
At that point, were you as a Smith County deputy interested in firearms or anything like that?
No, it was not.
Do you know if Van Zant County law enforcement who was there was interested?
I believe they were.
Your Honor, state passes the witness.
Mr. Stevens, your witness.
Thank you, Your Honor. Investigator McDonald, I'm Bill Stevens, going to ask some questions. If I don't make myself clear, just please stop me, okay?
Yes, sir. Thank you.
All right. Now, how did you derive at the fact that Mr. Young lived at that travel trailer?
By his own words.
By his own words, did he tell you that?
I was present during the interview that he was giving.
Okay. Did y'all, when you searched the property, did you find his clothing, shoes, clothing, underwear, things of that, like that in the travel trailer?
I don't remember exactly what all was found. I remember we found other evidence. It's been 4 years since that day, so I'm not quite sure exactly.
Other than his statement, was there any evidence that you found that tied him to that travel trailer?
Yes.
What was that?
His vehicle parked.
His vehicle?
His vehicle was parked in the vicinity.
Okay. So because his vehicle's parked there, that means he lives there?
And his own testimony.
No. Your investigation, he was not the target of your investigation, correct?
That's correct.
Okay.
He was not.
And to your knowledge, was he arrested for anything other than the sawed-off shotgun?
Not that I'm aware of.
Okay. What was the investigation all about that led you out to that location?
It was a burglary of a habitation that occurred in Smith County.
And what kind of property were y'all actually looking for?
We were looking for gold, coins, and other precious metals, firearms, and items that were specifically taken from that specific residence in Smith County.
I'll pass the witness, Your Honor.
Thank you, Your Honor. Investigator McDonald, we kind of danced around it earlier, but with the property that was stolen from the burglary, what was it that you located at this property?
Located a firearm. Oh, of the
From the burglary.
from our burglary in Smith County. I'm sorry. We located several gold coins.
And do you know approximately how many?
I believe around 10.
And where did you locate those?
We located those inside the orange Dodge Nitro.
And that's the Dodge Nitro that you said belonged to Mr. Young?
That's correct.
And you mentioned earlier that you overheard him state that he lived on the property. Can you clarify the circumstances around that statement?
Yes, he was willing to speak to detectives and other officers there. And while he was talking, he advised that the RV travel trailer was where he resided.
And Your Honor, state passes the witness.
Mr. Stevens.
Investigator, who was it, the Dodge Nitro titled in? Whose name was it titled in?
I'm not sure who it was titled to.
Well, did you run a report on it?
I'm sure somebody did. That was not my part of the investigation.
Ask witness, Your Honor.
Charlotte.
Nothing further, Your Honor.
Any objection to Investigator McDonald being finally excused?
Your Honor, we would ask subject to recall, but no objection to him going back to Smith County and just being within phone call.
Mr. Stevens.
No objection, Judge.
All right. So Investigator McDonald, you're not.
All right, that's your testimony. That's a reading of the indictment. That's the plea of the defendant and the first witness's testimony, which was the Smith County deputy that initiated an investigation at a location in Van Zandt County and subsequently turned up a short-barreled shotgun. We've got two of our witnesses for this case. And folks, if you're just joining in, this is a new format. We'll see a little bit this week. We'll see the next witness the following week. And in 4 weeks, we will have seen this entire trial up until the jury's. Good evening, folks. Welcome to Thursday night. We actually postponed the show. There was so much going on X that, and also end of the month with some of our jobs. We just pushed it one day to be ready. But we've got in the studio with us tonight, we've got Big Ron, our producer for the Grand Jury Show, and Bruce Wayne, also a producer for the Grand Jury Show. How you guys doing tonight?
Having a good night tonight, Joe. Looking forward to see part 2 of this. See what's going to go on with the prosecution and the defense, and see where we go. What direction is going to happen?
Yes, sir.
Yep, and we got a little bit of a recap we'll go into in a moment. But for those of you that are just joining us, or maybe your first time watching, this is our night court show, as we call it. We bring you real criminal prosecutions, real criminal court trials, jury trials. We show you the evidence that a jury sees, and then you get to see it sit as a jury member. Unlike what we do with the grand jury, every Friday night we bring 5 fresh folks on each week, and we do a decision right then and there. This is a little different. It takes a little while to get through the jury. You got to listen to all the testimony. You've got to hear all the hearings and the decisions made by the judge that affect the jury and the jury's instructions. So what we're going to do is, and we're going to run these in episodes. We started with episode 1 last week, and we'll recap that in case you missed it. But at about the 5th episode, it looks like it's going to be, we're going to bring in a 12-panel volunteer jury that's watched all the episodes and come in and let them deliberate and decide what they would decide, and then we'll reveal the real jury's verdict on this particular case. But what we're going over with, this is a case out of Texas, over a short-barreled firearm. I believe the actual statute reads something like possession of a prohibited weapon because it's, quite frankly, too short. And this is a felony offense. This is a gentleman that's on the hook in the great state of Texas. It could go to the penitentiary for the possession of this shotgun. But with that, if you're just watching, go back and catch the previous episode. Stay up to date. We'll select a jury from our Patreon members, paid tier members first. We'll select them. Let me throw that up there because that could be interesting for everyone to know. If you want to be on this jury, actually, hit that QR code, join our Patreon group, become a paid tiered member or a support tiered member, as we call them. And you have the opportunity to be on the jury come the 5th episode. which will be a 2-hour episode so we can get through the deliberations, and we'll also reveal the jury's verdict on how they decided to see how close you would look at the case. But I tell you what, gentlemen, why don't we go with a recap from last week's testimony?
We are now on record cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. And as I told you yesterday, Mr. Young, if you'll please rise. Mr. Hartwell, if you will present the indictment to Mr. Young.
In the name and by the authority of the state of Texas, the grand jury for the county of Van Zandt, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2021 of the 294th Judicial District Court for said county, upon their oaths present in and to said court at said term that Reginald Hoyt Young II, hereinafter styled defendant, on or about November 25th, 2020, and before the presentment of this indictment in the county and state aforesaid, did then and there, intentionally or knowingly, possess a short barrel firearm, to wit, an Eastern Arms 16-gauge shotgun, against the peace and dignity of the state, signed foreman of the grand jury.
Thank you, Mr. Hartwell. And Mr. Young, how do you enter a plea?
Not guilty.
Not guilty?
To be really kind of blunt about this case, it's fairly straightforward. On November 25th, you'll hear evidence that deputies with Smith County Sheriff's Office was investigating another incident that happened in Smith County. You'll hear that Mr. Young was not the subject of that investigation. In fact, the subject of that investigation was a man by the name of Russell Melton. However, during the course of their investigation, the deputies with Smith County were led to the property that Mr. Young resided on. You'll hear that they found some evidence from that Smith County incident on the property, and as follow-up, they got a search warrant and searched the property, where they found a sawed-off shotgun. Good afternoon, Investigator McDonald. Can you please start by introducing yourself to the jury and spell your last name for the court reporter?
Absolutely. Tim McDonald, Tim McDonald.
Can you tell me what the basics of that investigation was?
Yes, we were investigating a burglary that took place in Smith County.
What was found as a result of the search warrant?
We located a firearm that was found to be a violation of Texas law.
Mr. Stevens, your witness.
Thank you, Jonathan. Investigator McDonald, I'm Bill Stevens, going to ask some questions. If I don't make myself clear, just please stop me, okay?
Yes, sir. Thank you.
All right. Now, how did you derive at the fact that Mr. Young lived at that travel trailer? Other than his statement, was there any evidence that you found that tied him to that travel trailer?
Yes.
What was that?
His vehicle parked.
His vehicle?
His vehicle was parked in the vicinity.
Okay. So because his vehicle's parked there, that means he lives there? Your investigation, he was not the target of your investigation, correct?
That's correct.
Okay.
He was not.
And to your knowledge, was he arrested for anything other than the sawed-off shotgun?
Not that I'm aware of.
Okay. What was the investigation all about that led you out to that location?
It was a burglary of a habitation that occurred in Smith County.
And what kind of property were y'all actually looking for?
We were looking for gold, coins, and other precious metals, firearms, and items that were specifically taken from that specific residence in Smith County.
You mentioned earlier that you overheard him state that he lived on the property. Can you clarify the circumstances around that statement?
Yes, he was willing to speak to detectives and other officers there, and while he was talking, he advised that the RV travel trailer was where he resided.
Okay, there's your recap from last week. We had the reading of the indictment, the opening arguments, some of the stuff that's very formal in a criminal trial, a jury trial. We saw that. We also got into the first witness, and you saw some examples of what the first witness said. He's a detective. Now, this case actually is in one county, but started in an adjacent county next door through a burglary that led officers into this other county looking for items that were stolen in a burglary and an attempt to recover and arrest the perpetrators of the burglary. And they wound up going to an address, finding a gentleman there that was never charged with the burglary, wasn't charged with possession of anything from the burglary, and they found him to be in possession of a shotgun that was shorter than the legal limit, making it a prohibited weapon and making, I think the technical charge is possession of a prohibited weapon. It's a felony charge, pretty serious charge in the state of Texas. This man is looking at 5 to 10. He could be looking at with some enhancements, but 2 to 5 is probably a more appropriate range, as long as there's no other offenses or anything they can enhance it on if he were to be found guilty. So it's an interesting case, not a homicide like we normally see. It's like one of the police shootings we watch on Friday nights. But this is very interesting. And I want everyone to keep in mind, I have edited out. The only things that you are seeing and hearing are exactly what the jury that made the decision is seeing and hearing. No sidebars, no motions heard outside of the presence of the jury, no media. So this is rare. You make the decision off the testimony that you hear. Tonight, we're going to get into what we heard. I told you the two counties. One is Smith County. The other is Van Zant County. We're in a Van Zant County courthouse. The first episode was a Smith County deputy who was pursuing an investigation into a burglary in his county. But the final charge for this possession of a short-barreled shotgun, possession of a prohibited weapon, is in the county where they found it, which is in Van Zant County. So now we're going to hear from the second testimony. Is going to be, this guy's going to have a lot more detail. He's a Van Zant County criminal investigator from the Van Zant County Sheriff's Office. He's going to provide more detail, and the crux is on him. He's the arresting officer, essentially. The other officer explains how we got there, and when we got there and found these fresh offenses, he says, hey, we called the Van Zant County Sheriff's Office. They come out and said they were interested. They picked up the case and the evidence, and they moved on with it and filed the case for prosecution. So with that in mind, hey, you know what? We've got Fred. We got Fred. Fred, I'm going to bring you up on stage real quick before we get started. Fred's one of our Patreon support tier members, and he has carte blanche on the show. He can watch it from front stage, backstage, but he also has the opportunity to be a juror into this. So everybody watch this one coming up. This is going to have a lot more detail in it. Now, I'm going to warn you, there's a portion in here where they go to an audio tape, and they're watching. They've also got on a screen that we can't see some pictures, and they're going to talk about it. So listen to the testimony. You're not going to be able to understand the audio very well, but listen to the testimony, and they'll explain what they're hearing in there, and you make your judgment as whether you actually believe it or not. But it's going to get a little more interesting tonight. We're going to see the shotgun. We're going to see some more details of the investigation that we didn't see with our first witness. So first witness warms us up. Second witness gets us started. Episode 2, grand jury, going now.
Does the state wish to call another witness?
Yes, Your Honor. The people will call Lieutenant Bob Keltner.
Lieutenant Keltner. Sir, if you'll raise your right hand, do you swear that the testimony you give to the court today be the truth, whole truth, and nothing but the truth, so help you God? What's your step? Do your testimony is important that you speak up loudly and clearly so that everyone can hear what you have to say. Allow the attorneys to finish their question before you start speaking, so we're not talking at the same time, which makes it difficult. Okay. Mr. Hernandez.
Thank you, Your Honor. Good afternoon, Lieutenant. Would you please introduce yourself to the jury by stating your full name and spelling your last name for the court reporter?
Good afternoon. I'm Robert Aaron Keltner, Keltner. I often go as Bob.
And Lieutenant, I mentioned Lieutenant Bob Keltner. Is that your current title?
It is
And which agency do you work for?
Van Zandt County Sheriff's Office.
And how long have you been with the Van Zandt County Sheriff's Department?
Almost a year and a half this time.
This time? So
This
you
time.
have some prior law enforcement experience?
Yeah, I had a break in between 2021 and 2023.
And are you a post-certified peace officer?
I am.
Okay, and when did that certification first start?
I got my basic in 1991.
Okay, so how many years total in law enforcement have you had?
A little over 30. I had a break in the late 90s.
And what other agencies have you worked for?
I worked for the constable's office here, Precinct 4 in Van Zandt County. Been there almost 15 years, dual commissioned. And then, of course, the sheriff's office from 2017 to 2020. McCullough County Sheriff's Office in Brady, Texas. Did a short stint with the Van Police Department here in Van Zandt County, and the Kemp Police Department in Kaufman County.
And so fair to say that you've kind of come up the ranks and you started off as a patrol officer initially?
That's correct.
Okay. And when did you receive your commission for lieutenant here in Van Zandt County?
June of 2023.
Okay. So asking you to look back on to November 25th, the year 2020, were you working for the Van Zandt County Sheriff's Department?
I was.
Okay. And in what capacity? What title?
I was a sergeant investigator with in the Criminal Investigation Division.
And what were your duties in that capacity on that date?
I strictly worked property crimes or major crimes when it was necessary.
Do you have occasion to respond to 1255 Van Zandt County Road 4910 in Ben Wheeler, Texas, back on November 25th, 2020?
Yes, I did.
And was that location there and now, sir, in Van Zandt County, state of Texas?
Yes, it's in rural Van Zandt County.
Okay. Talking about middle of the day, maybe about 11:30, maybe noon. Does that sound about right?
Yeah, it sounds about right. We were there a good part of that day.
And how is it that you were called to that location?
The Smith County Sheriff's Office was investigating a property crime that occurred in their area, and they had ended up, as a result of their investigation, on 4910, and they requested us to come assist them, which is often the case when you're in somebody else's jurisdiction. You talk to who works there, at the very least, to let them know.
Because they were from Smith County coming into Van Zandt.
Yes.
I believe there was testimony about a courtesy call. Is that what he was referring to?
Yes, that would be the case.
Okay. And upon arrival there at that location, who did you meet with?
Met with Deputy Kevin Londoff and Deputy Tim McDonald with the Smith County Sheriff's Office.
Okay. And did they advise you of the purpose of their call and why they were at that location?
They did.
Okay. And as a result of that, what happened?
So they were there, like I said, investigating a property crime, which was a burglary. They had had a significant number of gold coins stolen out of a safe in the northwest portion of their county. And they had followed up some leads that led them to that location. And they had two individuals that they had detained there and were trying to forward their investigation.
And at any point, were you able to observe whether they were actually conversing with those two individuals?
I believe so. They were talking
Okay.
to those folks.
And one of those individuals, do you see that one of them here in the courtroom today?
I do.
Do you see Reginald Young, the second, here today?
Yes, sir.
Would you please describe where he is seated and what he is wearing?
He's seated here next to his attorney in a button-down shirt with his glasses on.
Your Honor, I'd ask the record to reflect identification of the defendant by this witness.
The description is a button-down shirt with glasses on, sitting next to an attorney. I'm not sure that that's a sufficient identification because they're both wearing button-downs. They're both wearing glasses.
Okay.
There's no presumption that one's an attorney over the other.
Okay.
Do you see somebody wearing a suit?
Yes, I do.
And who is that? Do you
I
know?
would assume that is his defense attorney.
Okay, and the person sitting to his right.
It is Reginald Young, a person I know is Reginald Young.
Okay, you know him as Reginald Young.
Yes.
At this time, I'd ask the record to reflect identification, Your Honor.
All right, record will reflect that this witness has identified the defendant, in this case, Reginald Hoyt Young II.
Now, Lieutenant Keltner, I'd like to ask you about body worn cameras going back to November 25th of 2020. Were those in use at the time by the Van Zandt County Sheriff's Office?
I believe that I had one issued to me there in that time. Yes.
Okay, and do you recall if that body worn camera was used by you on that date when you responded to that call?
I don't recall. We were leading up to the transition from one administration to the other. I don't remember whether I'd turned it in or whether I was wearing it that day.
And do you recall anything about CID and whether or not there was a policy as to whether body worn cameras would be worn by those investigators?
I don't recall a policy requiring CID to wear them at that time.
Okay. And so to your knowledge, did the deputies interview the defendant, Reginald Young, at that location?
I know that they did talk to him. Yes.
Okay. And as a result of that investigation, do you know if any of the alleged stolen property was found on scene?
As I recall, he did not consent to a search, so they were required to get a search warrant to advance their investigation there.
And was a search warrant obtained to lawfully conduct a search on that property?
It's my understanding that the Smith County Sheriff's Office, those deputies that were out there, had obtained a search warrant for that location. Yes.
And did you participate in any way with the processing of that area after the search warrant was signed?
Oh, yes. I assisted with searching a vehicle and other locations. Yes.
I may approach the witness, Your Honor.
You may.
So Keltner, I'm handing you what's been marked for identification purposes as States Exhibits 1, 2, 3, 4, and 5. Without actually displaying them to the jury, I'd ask you to take a look and see if you recognize those.
Yes, I do.
And what do those purport to be, sir?
All right. Number one is looks like an upright freezer.
Now, well, let me ask you a more general question. Are those all photographs? Do they appear to be photographs?
Yes, all 5 of them are photographs of what I recall to be the location of the search warrant.
Okay, and do they each and every one of those 1 through 5 clearly show the situation and what you observed back on November 25th, 2020?
Yes.
They've not been changed or altered in any way?
To my knowledge or detection, no. They look just like what they did back then.
At this time, I'd move for the admission of States Exhibits 1 through 5, Your Honor.
No objection, Your Honor.
All right, there being no objection, States Exhibits 1 through 5 are admitted.
I may approach the witness, Your Honor. We'd like to ask permission to publish at this time?
Yes, sir, granted. And Mr. Alternate, sir, Mr. Alternate, if you want to, you're welcome to bring your chair out. You can slide your chair out here so that you can get a better view so that you're not having to crane your neck up. Deputy Martinez, if you'll help me.
Mayor?
Yes.
Lieutenant Keltner, so, you would stand identified now and marked as State's Exhibit 1. Started to comment on that. What is that item?
It appears to be a stand-up freezer that was against the travel trailer at that location on 4910.
Okay. And do you recall what the makeup was? There's been a travel trailer discussed and a mobile home as well. Are those two separate
Yeah,
living quarters?
yes, two separate residents, I guess, or living quarters, yes. Two
Okay.
separate.
And this refrigerator or freezer, I believe is how you refer to it,
Uh-huh.
is in front of, is that the RV?
Yes, the RV travel trailer, yes.
I'm going to show you State's Exhibit 2.
Mm-hmm.
Is that same freezer?
That's
Door
the-
open?
Yes, it's the interior of it, yes.
Okay. And do you recall seeing, what is the item there on that center shelf?
That's the breakover shotgun in question today.
State's Exhibit 3 here, it's more close up. You see that there?
Mm-hmm.
Is that the same shotgun you're referring to?
Yes, it is.
And to your recollection, was there another firearm that was also located?
There was.
State's Exhibit 4. What is that there?
It's a 22 long rifle with a scope on it.
That's this here.
Mm-hmm.
And is that where it was located once law enforcement went into that RV?
Yes. Now,
Close up here, State's Exhibit 5. Right.
yes.
Now, who actually took possession of these two firearms, Lieutenant Keltner?
I believe I did. And I transported them back to the sheriff's office in Van Zandt County.
Back on State's Exhibit 3. Let me approach you, Your Honor.
You may.
Lieutenant Keltner, I ask you just to take a quick look and make sure that this item is safe. Ask you to identify it, please.
Okay, it is safe. This is a breakover shotgun that has been had the stock removed and the length of the barrel, or a length of the barrel.
And there's been some mentioning of a sawed-off shotgun. Is that the item in question?
That's how I would describe it. Yes, it does appear that the barrel was sawed off with most likely a hacksaw or something of that effect. It's what it appears. It doesn't. It's not clean. It does not appear to have been professionally modified.
Okay. Are you aware of instances where an item like that, a shotgun, can be professionally modified?
Yes, I would think so. I would think a gunsmith would be able to professionally modify a gun like that.
Now, are you aware of what the definition of a prohibited weapon is, Lieutenant?
Not verbatim, but yes.
Okay. Well, in measurements, What are we talking and
No,
what would you be looking at?
The barrel should be at least 18 inches long and the overall length should be 27 inches long, minimal. Otherwise, it requires a special permit or tax stamp.
And that's actually the item that was recovered from Reginald Young back on November 25th, 2020.
That is correct.
Does it appear to have been changed or modified in any way other than the identifying information that's attached to it?
No.
Your Honor, at this time I move for the admission of State's Exhibit 6.
Objection to state 6.
Oh, it's the sticker.
Oh, no objection, Judge. No objection.
All right, there being no objection, state's exhibit 6 is admitted. Deputy Martinez, will you get this from Lieutenant Hilton?
Thanks, sir.
Right on that line.
Let me approach the witness, Your Honor.
Yes, sir, you may.
Lieutenant Keltner, I'll ask you to take a look at what's been marked for identification purposes as State's Exhibit 7. It's a box currently there. Can you take a look to see if it bears any identifying information?
It does.
And whose name appears on that box?
My name appears on it.
Okay. And do you know when that box would have been put together in that fashion?
Well, I collected it on November the 25th, 2020. I did not box this particular piece of evidence myself.
Okay. But you actually brought an item from Mr. Young's residence back to the Sheriff's Department.
That is correct.
At this time, I'd ask you to go ahead and break the seal on the box and then look at the contents without actually pulling out that item.
The seal is already broke on it.
Okay. Does that look to be fairly the same item that you recovered back on November 25th, 2020?
Yes.
Has it been modified, changed in any way?
It appears that the scope has been removed from the top of the rifle.
Okay.
This is my handwriting on the tag.
If you wouldn't mind just taking a quick look and making sure that it is safe.
Can I cut it out of the box?
Yes, you need Deputy Martinez's knife.
No, I have one if that's all right.
Yes, you can cut it out.
I believe the weapon is safe.
All right.
It is on safety.
Your Honor, at this time, the state would move for the admission of State's Exhibit 7.
Any objection to state 7?
Your Honor, I got a couple of questions of the witness on State's Exhibit 7.
All right, go ahead.
Officer, you testified just now that the seal had been broken on the box.
Yes,
Okay. Did you break the seal?
I did not.
Do you know who broke the seal?
I do not.
I'll object to the admission of this evidence, Your Honor. Seal's been broken. He doesn't know who broke the seal. We don't know if that was actually the weapon put in there at the time.
Response from state.
I believe he testified that it is the weapon, Your Honor, that was placed in the box, other than the fact that the scope was taken off the weapon. That was the testimony.
All right, then the court will overrule the objection and state 7 is admitted.
Please note my objection.
Yes, sir, it is noted for the record.
If I may approach the witness, Your
You
Honor.
may.
Seal it up.
You can stay on the floor. All right, sir.
Thank you. Now, Lieutenant Keltner, I'll make reference back to State's Exhibit 6, but it has been admitted there. And handing you a standard Stanley 12-foot measuring tape.
Okay.
You testified to the fact that there's a certain length that you're looking for and what qualifies as a prohibited weapon. What was that number in terms
Anything
of
under
barrel
18.
length?
Anything under 18 inches.
Would you please take a moment and measure the length of that barrel there?
Shows a 16th over 11 inches.
So that's almost
11
7
inches.
inches.
Yeah, 11 inches and a 16th,
And it should be
18 inches. So it's well under.
7 inches.
Yeah.
I think even I can do that math.
Uh,
All right. And then you also stated that there was a overall length that you're looking at.
of 26 inches.
And would you please just take a moment and measure that?
Or I think I do. Wow. Folks, my apologies. I do not have time to go and pick up the rest of this. I don't think. You know what? Give me just a second. Give me just investigators text to be able to give. I don't care how many times you've done it. Every time you get up there, you're nervous because you are being scrutinized. Very bright. I think that slows me down a little bit. You know, the more you know, right? That
You really couldn't even verbalize what a prohibited weapon was. But help me fill in a piece I missed.
sometimes it's a firearm with a wooden stock. I'll get out of the paper, and you do want it in a bong. If I were to take this for this case,
Piece of paper.
No, I think we're good.
Yeah, I think we're good here.
That's the breakover shotgun in question today.
State's Exhibit 3 here. It's more close up. You see that there?
Mm-hmm.
Is that the same shotgun you're referring to?
Yes, it is.
And to your recollection, was there another firearm that was also located?
There was.
State's Exhibit 4. What is that there?
It's a 22 long rifle with a scope on it.
I think I'm early.
That's this here.
Mm-hmm.
Yeah, you need to go forward, Joe.
Okay, it is safe. This is a breakover shotgun that has been had the stock removed and the length of the barrel, or a length of the barrel.
Did you see the stock when he raised it in his
And
right
there's
hand?
been some mentioning of a sawed-off shotgun. Is that the item in question?
That's how I would describe it. Yes, it does appear that the barrel was sawed off with most likely a hacksaw or
Yeah,
something to that
most
effect.
likely.
The barrel should be at least 18.
State's Exhibit 6.
on it.
Okay. And do you know when that box would have been put together in that fashion?
Well, I collected it on November the 25th, 2020. I did not box this particular piece of evidence myself.
Okay. But you actually brought an item, look to be fairly the same item that you recovered back on November 25th, 2020?
I believe the weapon is.
Any objection to state the seal?
I did not.
We testified that it is the weapon, Your Honor, that was placed in the box, other than the fact that the scope was taken off the weapon. That was the testimony.
All right, then the court will overrule the objection and state 7 is admitted.
Please note by judge.
Yes, sir. It is noted for the record.
If I may approach the witness, Your
You
Honor.
may. Where, you just laid on the floor. All right, sir.
Thank you. Now, Lieutenant Keltner, I'll make reference back to State's Exhibit 6, but it has been admitted there. And handing you a standard Stanley 12-foot measuring tape.
Okay.
You testified to the fact that there's a certain length that you're looking for and what qualifies as a prohibited weapon. What was that number in terms
Anything
of
under
barrel length?
Anything under 18 inches.
Would you please take a moment and measure the length of that barrel there?
Shows a 16th over 11 inches.
So that's almost
11
7
inches.
inches.
Yeah, 11 inches and a 16th,
And it should be
18 inches. So it's well under.
7 inches.
Yeah.
I think even I can do that math.
Uh,
All right. And then you also stated that there was a overall length that you're looking at.
of 26 inches.
And would you please just take a moment and measure that?
In the name and by the authority of the state of Texas. The grand jury for the county of Van Zandt, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2021 of the 294th Judicial District Court for said county, upon their oaths present in and to said court at said term that Reginald Hoyt Young II, hereinafter styled defendant, on or about November 25th, 2020, and before the presentment of this indictment in the county and state aforesaid, did then and there intentionally or knowingly possess a short barrel firearm, to wit, an Eastern Arms 16-gauge shotgun, against the peace and dignity of the state, signed foreman of the grand jury.
Thank you, Mr. Hartwell. And Mr. Young, how do you enter a plea?
Not guilty.
Not guilty?
To be really kind of blunt about this case, it's fairly straightforward. On November 25th, you'll hear evidence that deputies with Smith County Sheriff's Office was investigating another incident that happened in Smith County. You'll hear that Mr. Young was not the subject of that investigation. In fact, the subject of that investigation was a man by the name of Russell Melton. However, during the course of their investigation, the deputies with Smith County were led to the property that Mr. Young resided on. You'll hear that they found some evidence from that Smith County incident on the property. And as follow-up, they got a search warrant and searched the property, where they found a sawed-off shotgun. Good afternoon, Investigator McDonald. Can you please start by introducing yourself to the jury and spell your last name for the court reporter?
Absolutely. Tim McDonald, TIM, McDonald.
Can you tell me what the basics of that investigation was?
Yes, we were investigating a burglary that took place in Smith County.
What was found as a result of the search warrant?
We located a firearm that was found to be a violation of Texas law.
Mr. Stevens, your witness.
Thank you, John. Investigator McDonald, I'm Bill Stevens, going to ask some questions. If I don't make myself clear, just please stop me, okay?
Yes, sir. Thank you.
All right. Now, how did you derive at the fact that Mr. Young lived at that travel trailer? Other than his statement, was there any evidence that you found that tied him to that travel trailer?
Yes.
What was that?
His vehicle parked.
His vehicle?
His vehicle was parked in the vicinity.
Okay. So because his vehicle's parked there, that means he lives there? Your investigation, he was not the target of your investigation, correct?
That's correct.
Okay.
He was not.
And to your knowledge, was he arrested for anything other than the sawed-off shotgun?
Not that I'm aware of.
Okay. What was the investigation all about that led you out to that location?
It was a burglary of a habitation that occurred in Smith County.
And what kind of property were y'all actually looking for?
We were looking for gold, coins and other precious metals, firearms, and items that were specifically taken from that specific residence in Smith County.
All right, sir, if you'll raise your right hand, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay. And upon arrival there at that location, who did you meet with?
Met with Deputy Kevin Londoff and Deputy Tim McDonald with the Smith County Sheriff's Office.
And did they advise you of the purpose of their call and why they were at that location?
They did.
Okay. And as a result of that, what happened?
So they were there, like I said, investigating a property crime, which was a burglary. They had had a significant number of gold coins stolen out of a safe in the northwest portion of their county. And
Just to take a quick look and make sure that this item is safe. Ask you to identify it, please.
okay, it is safe. This is a breakover shotgun that has been had the stock removed and the length of the barrel, or a length of the barrel.
Okay.
The barrel was sawed off with most likely a hacksaw or something to that effect. It's what it appears. It doesn't. It's not clean. It does not appear to have been professionally modified.
In measurements, what are we talking, and what would you be looking at?
The barrel should be at least 18 inches long, and the overall length should be 27 inches long, minimum.
No objection, Judge. No.
All right, there being no objection, State's Exhibit 6 is admitted.
What qualifies as a prohibited weapon? What was that number in terms
Anything
of
under
barrel
18
length?
Anything under 18 inches.
Would you please take a moment and measure the length of that barrel there?
Shows a 1/16 over 11 inches.
Now, my client was not charged with anything related from the burglary. Is that correct?
That's my understanding.
Okay. Lieutenant, did you take any fingerprints from the shotgun?
I did not.
You did not. Do you know if anybody took any fingerprints?
Not to my knowledge.
Okay. Did you ever see Mr. Young possess? I mean, with your eyes, did you ever see Mr. Young possess the shotgun?
No, I did not see it in his hands or on his person. So no, I did not.
Okay. So is that sawed-off shotgun operable?
So I would not consider it operable at this time. No.
Counsel also asked you about whether that sawed-off shotgun is operable. What would it take for it to be operable?
Simply sliding a firing pin into position and loading it.
How long would that take to slide that firing pin?
Just a few seconds.
Right. Third, you swear that the testimony you give before today, truth, the whole truth, and nothing but the truth, so.
Yes.
See, Martinez, during your testimony, support that you speak up loudly and clearly, you have to lean to the microphone. During your testimony, if the attorneys object, just a comment, we'll move on now. allow the attorneys to completely finish their question before you give an answer, so we're not talking at the same time. For purposes of a clear record. Finally, if you're in the emergency vehicle or voucher, sometimes it makes it difficult. Because the line of that sound pass, the attorneys may be stopping their questioning here.
Okay. Thank you, Your Honor. Good afternoon, Agent Petrie. Can you please introduce yourself to the jury by stating your full name and spelling your last name for the court reporter?
My name is Joshua Petrie, Petree.
And can you tell me what you do for a living?
I'm a special agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
What does somebody have to do to become a special agent with the Bureau of ATF?
Well, we investigate federal crimes. So typically, like I have a bachelor's degree. I was a police officer prior to. And so it's there's different paths, but typically you're prior law enforcement before you become a federal agent.
So starting kind of with your education, what do you have a bachelor's degree in?
So I have a associate's degree in criminal justice, a bachelor's degree in criminal justice, and a master's degree in business administration.
And about how long did it take you to get those degrees?
Long time, approximately 10 years. I was a police officer while I was also going to graduate school.
And where were you a police officer at?
University of Texas at Tyler.
And to be a police officer with UT Tyler, did you have to be a certified police officer?
Yes, I went through the UT police system in Austin, Texas.
Can you tell me a little bit about that system?
It's a 6-month training, typical police academy where you're learning policies and procedures, state penal codes, arrest techniques, driving techniques, shooting, hand-to-hand techniques, various generalized law enforcement.
And about how long were you a police officer?
4 years.
And is it at that point after your degrees and your experience as a police officer that you applied to be with the ATF?
It took me 4 years to be hired. So while I did an internship with ATF when I was going to UT Tyler on my undergraduate degree. Knew that was my goal, became a police officer to gather the experience. The hiring process was approximately 4 years.
Can you describe a little bit about that process?
Process of being hired?
Yes, sir.
It's very stringent. Typically, ATF has 2,500 federal agents throughout the United States. It's always been about that size. Our attrition is usually people that retire. It's approximately 100 agents a year. They open up the vacancy announcement, which is the generalized open application process. Typically, 5,000 to 10,000 people apply. They hire about 100 a year. So it's very, very stringent.
And once they hire you, can you tell me a little bit about that process?
Yes. So they sent me to Tulsa, Oklahoma. I got the duty agent phone call that said I was being hired and went to Tulsa, Oklahoma, worked there for approximately 6 months till I was assigned an academy date. ATF attends a training academy in Glencoe, Georgia. It's also where, at the time, Border Patrol, U.S. Marshals, Customs, Secret Service, a lot of your federal agencies have combined training at this one facility in Glencoe, Georgia.
And so would Glencoe be kind of the equivalent of like Quantico for FBI?
Yes.
And can you tell me a little bit about your experience at Glencoe?
Sure. The entire training process there was approximately 6 months. Half of that was a generalized investigator training for those that basically didn't have law enforcement prior to. It taught you the laws and procedures and techniques of investigation, typically, because we are criminal investigators. And then the second half was more specific towards what we deal with as ATF agents: alcohol, tobacco, firearms, explosives, commercial arson, stuff more specialized towards what ATF agents do in general.
And so you mentioned some of your college education. Do you have any furthering education specific to while you've been on the job?
Yes, I'm also considered a firearms interstate nexus expert. What that means is I'm an expert and have been declared expert in numerous courts throughout the country. of identification of firearms, the markings where they're made, when they're made. I've toured numerous manufacturing facilities throughout the United States. I also go back and teach various blocks of that at our training academy.
And Your Honor, may I approach the witness?
Me.
And Agent Petrie, I'm going to show you what's enlarged and admitted as State's Exhibit 6. Can you take a look at that item?
Yes.
Can you describe what that item is?
This is a weapon made from a shotgun. It can be classified in two different manners. Weapon made from, because lawfully to possess firearms like this, they have to be an overall length of 26 inches and or the barrel has to be at least 18 inches long because it's a shotgun. And it's obvious that this one has been shortened on both the buttstock and the barrel.
And would you classify, so that appears to be a modified shotgun?
Yes, it originated its life as a shotgun that people would fire from the shoulder, typically for hunting of birds or things of that nature.
So in your training and experience, does that appear to be a prohibited weapon?
Yes.
And is that due to the length?
Yes, these are considered concealable. Therefore, they're prohibited because they can be hidden under trench coats. The laws were originated with these weapons back in the early 30s when mobsters would carry them and Tommy guns underneath their trench coats because they're considered weapons of violence and they're readily concealable.
And Agent Petrie, can you tell me, does that shotgun appear to be readily operable right now?
It meets the definition of a firearm. I haven't actually tested it to see if it functions, but it was intended to be a weapon and it is capable of being readily converted to fire if it won't fire in this form.
And if I told you that the shotgun did not have a firing pin, could you tell me the process that it would take to
if that's the case, it's a pretty simple procedure to drop a firing pin in. This type of shotgun right here was manufactured by a J. Stevens company in the early 1900s to the 50s. They sold these types when they were in original form in like Sears and Roebuck's catalogs back in the day. There's probably hundreds of thousands, if not millions, of these very similar type shotguns that could use interchangeable parts.
And Agent Petrie, I want to kind of turn your attention to your when you became involved in this investigation. Do you recall December 4th of 2020?
Yes.
And did you have a chance to interview Mr. Young on that date?
Yes.
And Your Honor, may I approach again?
Yes, sir, you may.
Thanks. I'm going to show you what's been admitted as State's Exhibit number 8. Do you recognize that document, sir?
I do.
What is it?
This is a U.S. Department of Justice Advice of Rights and Waiver, commonly a Miranda waiver that is either read by somebody that you're interviewing. Typically, they're in custody. And I often read it to them, ask the person I'm interviewing that's in custody that has the right to an attorney if they want to waive that privilege to continue with the interview.
And is that the process you followed on December 4th of 2020?
Yes.
And did Mr. Young indicate that he understood his rights?
Yes.
And did he indicate that he wished to waive his rights and speak with you?
Yes.
And Your Honor, may I approach again? Thank you. And do you know whether Mr. Young was recorded?
Yes, it was.
Have you had an opportunity to review that recording?
Yes.
And the recording that's on that thumb drive, does it appear to be an accurate representation of the conversation?
I don't know what's on this thumb drive. This appears to be a way a typical interview recording would be turned into the prosecutor's office. It's labeled with the case number, things of that nature, but without seeing what's on the thumb drive, I honestly don't know.
And Your Honor, At this point, the state would request to give Agent Petrie a chance to view the thumb drive to make sure that it is in fact the interview that he conducted.
What was the video?
The entire video is about 15 minutes, Your Honor.
All right, of course, going to stand in recess for 20 minutes to allow the witness to take the content on State's Exhibit 9. You are reminded that you've not heard all of the evidence in this case, not received the court's instructions on jury charge, and you've not received closing arguments, so you've not discussed this case with one another or anyone else, okay? So you're not required to stay in the jury room, go outside, take a break, welcome to do so. It's 20 till 3, so let's make sure that we're back in the jury room no later than 3 p.m. and make sure. Okay. All rise. Well, it's not to comment on it. Court's in recess. Pick up there. Go ahead, Mr. Harwell. 98 stated. The second record reflects that the attorneys for the state, attorney for the defendant, and the jury is present. I believe that before the recess, there was a question to Agent Petrie regarding State's Exhibit 9. Just refresh the recollection of the jury. If we'll go ahead and pick up there, go ahead, Mr. Harwell.
Thank you, Your Honor. And Agent Petrie, have you had an opportunity to view the video that's on State's Exhibit 9?
Yes.
And does that video appear to have some muted portions?
Yes.
What is your understanding of those muted portions?
Parts of my conversation with Mr. Young involved things not relevant to this particular criminal investigation.
And other than those portions, is it a true and accurate copy?
Yes.
Your Honor, State offers State's Exhibit 9 with agreed redactions.
Any objection?
No objection, Your Honor. We've reviewed it.
Okay, then State's Exhibit 9 is admitted.
And Your Honor, permission to publish to the jury.
Granted.
And Your Honor, the alternate would.
Yes, sir. If you want to move out, you can, or if you just want to turn your chair and slide it back, if that's fine. Just whatever is most convenient for you. Yes. And if you could probably roll that cabinet back too, Mr. Harwell, if you want to. There's still room. Stevens, can you see it from there?
Yes, sir.
Excellent.
You see it okay?
All right, folks, you're going to have to bear with this. They're about to play an audio recording or video recording. We can't see it, and with the echo in the courtroom, you can't understand it very well. But listen to the questions. They'll play a portion of the video, and then they'll ask this guy more questions about that video. So you'll be able to ascertain what the video is about and what he's asking about. It's going to pertain to, once again, the ownership of the firearm. And I hope my audio is now working. I had a snafu here on inputs, but I think I'm back running. Now, once again, you're listening to a video that was made on the scene at the day of the arrest. The audio quality is just not good in the courtroom as far as picking it up on the mics. So you'll have to kind of bear with that. But if I edit it out, you'll miss his answers. He's going to be asked a series of questions about this video audio as it progresses.
Are you ready for the CRI? So you ready to get a stream test? I've got these to write. Good right from the stop. Anything you say, please be recorded. You have the right to talk to a lawyer before asking any questions. Have a lawyer with your questions. You cannot afford a lawyer. Don't get a lawyer.
You can hear them reading the Miranda rights on the audio that they're listening to in the courtroom.
If the waiver that you have read these rights by me, you understand them, to the time you will answer questions about lawyer presence. No problem. The rest of it may, no pressure force anytime you get you. But I got back down by the.
Yeah, and then another audio is difficult to hear. Let me help you out. This is the defendant speaking on a recorded device on the day that he was arrested, where they found the shotgun. He's explaining that this is not his house, but it's his mother's house, is the conversation that they're having now.
Where did you get locked up at? Okay, yeah. Oh, have you ever had a fire? I know somebody that looked at it. It's not what you're fine. But no, very close that, given research that's fine.
Now they've asked him about how do you fire the shotgun, and he's saying I've never seen it fired. I don't know. Is basically what he said with most of that.
I know my girl, and I said that my heart beat really well with my girlfriend, but it's not bad. So that's able to have in the home. Whenever they woke me up, and they, yeah, I don't remember what I mean, but the first it was Tyler's birthday, it was about they were actually So the 22 rifle comes from the same place. You know, 5 years.
And now he's talking about a rifle that was also found on the property, but he wasn't charged in this case with anything to do with that rifle. We did see them presented into evidence, but he wasn't charged with any part of that.
I don't know if you know them very well, but I don't look at them.
And while the audio is bad, I want to make another public service announcement. You never want to be a defendant and listen to yourself talking on a audio tape when the witness is not saying anything really about you. You're testifying. They're letting you testify against yourself, and they warn you anything you say can and will be used against you in a court of law. Don't be that guy. Now, another interesting portion of this was that last part where he says, "Why didn't you get rid of it?" What the defendant's saying is, "It's not my shotgun. I found it. It was in a car. I'm not sure if it was his car. Someone left it there." He takes it out and puts it into the freezer because he didn't want to have anything to do with it. Doesn't take it inside the house that he's living. Puts it in the freezer that's on the ground outside where they're living. So that's what the defendant's saying about this, and you'll see this pop up again in the defense's case.
Again, he said it looked like it was when it first got there, it was kind of roughed up, you know what I'm saying? And it looked like somebody like me tried to clean it up, but I don't know, because I just know that I know for sure that it does not have fire, and I know it can do nothing.
Now they're talking about the firing pin in the shotgun. In Texas, it's very important that the firearm be operational. You could take I could take a machine gun from the military as a war trophy, lead the barrel, weld the action so that it can't be used, and it would be as the defense attorney said in this one, a relic, but it would be considered a curio, art piece, something you could hang on the wall, not a functional firearm. So the fact that this doesn't have a firing pin in it is a key part of this case. And they're asking him about whether he knows how to change a firing pin out, and he's saying, I don't know anything about it. He's saying he didn't know it didn't even have a firing pin. He said lacks that much knowledge about that particular weapon.
And Agent Petrie, I just have a couple of follow-up questions. Was there anything that stood out to you about Mr. Young's discussion about firing the 22 rifle?
Yeah, my knowledge of the investigation, the 22 rifles in close proximity to the sawed-off shotgun.
And what would that the proximity and firing the 22? What would that indicate to you?
The knowledge that the firearms were there, knew that one worked and one didn't, which meant must have tried, or he's told me that somebody else did, but.
And there was some discussion about a firing pin, and you had mentioned that it doesn't matter according to the law. Does not having a firing pin, does that make a weapon not a firearm?
No, it just says it has to be readily converted or is intended to be fired by the means of an explosion. A firearm itself is a weapon, whether it's fired or not. It can be pointed at somebody and have the same intention. But if it's created to be a firearm, then it's a firearm.
And then your discussion about the fingerprints on the shotgun seemed Mr. Young was kind of equivocating there. What does that tell you in your experience as an agent?
That's a typical question I ask because a lot of people watch CSI, think that we get fingerprints off of everything, which is not accurate at all, especially when they're dealing a weapon like this. But what it does is it gives a measure of truthfulness. And when I saw him start to stammer and sputter, which is a common deceptive technique, I knew that he was probably worried about that question.
And then when you mentioned not looking to charge Mr. Young's mom, can you go into that a little bit and that exchange?
Correct. Throughout that interview, Mr. Young was trying to what I considered minimize his criminal involvement with this. He knew I was questioning him about it. So ways of doing that are to minimize what I knew or what I had, and then also try to place the blame on others. I could tell throughout the interview that although he acknowledged he knew it was there and in its presence, he was trying to blame, he tried to say that his mother went and got it after he initially told me that Mr. Waddell called him. He said that Mr. Waddell, that his mother went and retrieved them and then brought them back to the house, which I informed him that is a violation of federal law because that's a prohibited weapon. And I wasn't looking to get his mother in trouble. The charge, when I used the word charge, meant get your mother in trouble. I just wanted the truth. I could tell that he was trying to deflect.
And then last question, are you familiar with, to your knowledge and experience, is there a definition for an antique gun?
Yes.
And would this firearm meet that definition?
No. Antique firearms are like muzzle loading firearms, black powder. They use an antique ignition source, or if they're manufactured prior to 1898. I'm familiar with these firearms. They were manufactured well after the 1900s, and it doesn't use an antique ignition system and doesn't take black powder. So it's what we consider a modern firearm.
Okay. Your Honor, state passes the witness.
Mr. Stevens, your witness.
Thank you, Your Honor. Special Agent Petrie, I'm Bill Stevens. I'm going to ask some questions. If I don't make sense, please just stop me.
Yes, sir.
All right. Now, was Mr. Young pretty much cooperative throughout that entire interview?
Yes.
And he did start off at first, correct me if I'm wrong, but didn't he start off at first telling you that his mom is the one that put the shotgun and also a TV in her trailer?
Well, yes, he changed his story a couple of times. He tried to tell me that it wasn't his trailer, but then he clearly says on the video that my house, my girlfriend must have moved him out of my house and they were underneath the TV. So I was never clear on the relation to when they got there, how they got there, or what the TV had anything to do with.
But he did initially say that his mother wouldn't put him in there, correct?
Yes.
Initially. Okay.
Yes.
And then I believe his story might have changed after you, I don't want to say threatened him with his mom, but after you made the comment about, you're not going to throw your mom under the bus, are you? This is a federal offense. And that's when he then changed his story. Am I correct on that?
Correct. I was calling out his falsehoods to let him know that by him pointing his finger at somebody else and trying to place the blame, he could actually get them in trouble.
I know fingerprints were not taken from the shotgun. However, could they have been taken from the shotgun?
From that shotgun there?
Yes.
It could have been submitted, but they wouldn't have got anything off of it because of the rust and the wear. There's based on my training experience, there's nowhere on there that latent prints would be able to hold.
Okay. And do you have any way through your examination to determine when that shotgun was last fired?
No, sir.
So it might not have been fired for 30 years for all we know. Is that correct?
Possible.
Now, I just want to make sure the jury understands something. You were out there investigating this burglary initially, is that correct?
I never went to the scene that day.
Okay, but I mean, wasn't the feds investigating the theft of the gold coins?
Yes, I was assisting the Smith County Sheriff's Office with that.
Right, sir. And my client was not involved or not charged with anything involving the gold coins, correct?
I don't know that,
Okay.
to be honest.
You don't know if he was or was not.
Correct.
Okay. He was cooperative with you, was he not? When
Yes.
you're asking him about the gold coins.
Yes, sir.
Did his interview help you in any way locate the people that was responsible for stealing the gold coins?
Yes.
Ask the witness, Your Honor.
Mr. Harwell, your witness.
Thank you, Your Honor. Just real quick follow-up, Agent Petrie, mentioned earlier that without a firing pin, it's still a firearm. So kind of a follow-up question to that, without a firing pin, would it still be a prohibited weapon?
Correct.
State pass the witness, Your Honor.
Mr. Steven,
No further questions.
any objection to Agent Petrie being finally excused?
Your Honor, state would ask that he be subject to recall, but no objection to just being within a phone call.
Okay, Agent Petrie, so you're still able to discuss your testimony with anyone else, allow them to discuss their testimony with you, not required to stay in the courthouse, but subject to recall by both the state. Yeah, that's your statement. All right, does the state wish to call any additional witnesses?
No, Your Honor, state rests.
State rests its evidence at this time.
Yes, sir.
Mr. Stevens, would you like your opening statement at this time?
No opening statement, Your Honor.
So that's waived. Does the defense wish to call any witnesses?
Yes, Your Honor.
Who would you like to call?
Sheila Prater, Your Honor.
Sheila Crater?
Prater.
Prater.
Prater, yes, sir.
E-R-A.
Prater.
Thank you.
I believe that's how it's spelled, Judge.
This is going to be the defendant's mother they're calling to the stand, the one that was throw you under the bus comment.
You raise your right hand. So the question there, you swear that the testimony that the court today will be the truth, the whole truth, and nothing but the truth. So making that once you're still up, because you okay, that chair does move around, so you can adjust it. Just make sure I see that you have your cell phone. If you wouldn't mind just like giving he does have that, let him have that so make sure it's really quiet.
But, okay.
Adjust your chair so we can closer to the microphone.
Okay.
Prater, during your testimony to the court, speak up loudly and clearly so everyone can say. My court reporter here is taking down the record of everyone's saying, okay? So
Okay.
it's very important that you allow your attorneys to answer the questions before you give an answer, so we're not talking at the same time, which will be very difficult for her. If during your testimony, either attorney objects, they stand up, so Your Honor, I object. Just stop testifying, the court will rule on that, or let you know whether it's or not, okay? And then finally, if you hear an emergency vehicle or a loud truck, the attorney's going to stop asking questions. If that happens to your testimony, want you to stop so that sound can pass, so that we can all hear what you have to say, okay? Mr. Stevens.
Judge, may we approach?
You may.
There's going to be some discussion about whether her testimony would incriminate her. And that's what they're doing a little sidebar with right now.
Ladies and gentlemen, there's a legal issue that must take up outside your presence. So I'm going to put you in recess. I'm not sure how soon. So it's about 20 till 4. I'm going to say let's do the recess for 50 minutes. We're back in the jury room no later than 3:55. Checking on it. Remember to follow the instructions I've given you so far. Don't discuss this case with each other at any time. Okay, let's all rise for the jury.
All right, folks, I left this portion in. This is technically, the jury won't hear what's about to happen, but I think it's important to something that we talk about a lot on my platform, which are what your rights are and what law enforcement is there to do.
A suggestion that are you going to be seated?
All right, let the record reflect that the jury has been excused, that this hearing is conducted outside their presence. Court has done so on the suggestion that some of the questions may implicate the Fifth Amendment rights of the witness, Ms. Prater. And is your name Sheila Prater?
Yes.
Is it Sheila?
No. LIA.
LIA?
Yes.
Is it PRATER?
Yes.
Thank you, ma'am. And so I think at this time, what I would do is just allow you, Mr. Stevens, to just summarize what issues that you believe are going to be the subject of Ms. Prater's testimony that could implicate her Fifth Amendment rights.
Yes, Your Honor. I'll be asking her, we've heard testimony already that it's stated that my client put the shotgun in the travel trailer and that my client lives there. Her testimony is going to be that she is the one that put the shotgun there and that my client doesn't live there, that she did. With that being said, it's a prohibited weapon. And if she testifies that she put it there, then that could open herself up to liability. So that's my concern, Your Honor. And I did visit with Ms. Prater and I did explain those, concerns with her. So that's a perimeter of kind of what I'm talking about, Judge.
Any response from the state?
So, Your Honor, I guess in light of that, of those facts, I don't know that it's necessarily relevant to the case at bar in light of the fact that it's a possession of the weapon as to who moved what or where, but rather the fact that he was aware and he's testified to the fact that he had them there.
Right. This is not a question about him. This is a question about her. Do you have a response to his questioning of her, whether or not she should have counsel? I just want to.
Well, she absolutely should if she's going to be admitting that she in fact was handling an illegal weapon.
So what's the statute of limitations for possessing a prohibited weapon?
Your Honor, I believe under the state it would be 3 years. I don't know what it would be federally though.
We need to find that out. I think you have an ATF agent who's.
Is he still hanging around? We can find out real quick.
Perhaps you should step out and give him a call. I don't know what the statute of limitation is for.
I don't either.
For a federal allegation of prohibited weapon. If it's. When did the Van Zandt County Sheriff's Office take possession of this weapon? On November 25th, 2020?
Yes, sir.
So here we are almost 4 years later. So if the statute of limitations has run, then there might not be any criminal.
No, that's true. If it's run.
Now, that begs the question, doesn't mean that law enforcement couldn't make an allegation. It just means a prosecution can't be had. It doesn't mean that a law enforcement officer couldn't be standing outside the door waiting to arrest her. Just means that a prosecution wouldn't be successful because it wouldn't be timely. Right. You all agree?
Yes, sir.
Yes. Okay. So what I would like to do is I'm going to stand in recess for a few minutes. I would ask the state to contact Agent Petrie and see if you can get a quick answer for the court and a reference to the CFR that or whatever, or USC, whatever the reference is. And get the court a quick answer on that, so I don't have to go research that.
Okay. What we're seeing here is proper. This woman is going to get on the stand, and if she says that she was in possession of a short-barreled shotgun, she could expose herself to criminal prosecution both on a state and a federal level. So we don't ask people to testify against themselves. You have a constitutional right not to do that, your Fifth Amendment, and I think the judge is being proper with this.
Number CR 21-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of the jury. Due to the nature of the direct examination and potential cross-examination of this witness, Miss Sheila Prater, the court finds that her Fifth Amendment rights against self-incrimination could become an issue. And so the court has found Ms. Prater to be indigent, and the court is going to appoint the Honorable Richard Schmidt to advise Ms. Prater both prior to and during her testimony regarding her Fifth Amendment rights. The court tomorrow, after she has received the advice of counsel, will also admonish her as to her Fifth Amendment right. But unfortunately, Mr. Schmidt would not be available today on such late notice. It is 4 p.m. So I think it's best to recess for the day. So I'm going to tell the jury that we're going to come back in the morning at 9 a.m. Ms. Prater, I'm going to order you to come back at 8:30 in the morning. 8:30 in the morning, and there you will meet with Mr. Richard Schmidt, attorney.
Okay.
And he's going to talk to you about your testimony and any implications it could have regarding any potential arrest or prosecution that could stem from that. Okay. And so I don't want you to say anything at this time, but you'll meet with him in the morning and he will advise you and counsel you. And he'll be here during your testimony and can be here if you have any legal questions. Okay. And so I believe you've given the contact information to my coordinator, Ms. Tabraham. Is that correct?
Yes.
Okay. And so I'm going to order you to come back at 8:30, and then we'll begin promptly at 9 a.m. Any issues on that matter from counsel?
No, sir.
Any other?
No, sir.
Any other issues we need to take up?
No, sir, not that I'm aware of.
All right. So the defense has indicated that they believe that Ms. Prater will be the last defense witness. Is that correct?
That is correct, Your Honor.
Okay. All right. So Ms. Prater, I'm going to go ahead and I'm going to leave you where you're at.
Okay.
The jury in, and I'm just going to let the jury know that there's an issue that we're going to deal with and that we're going to resume tomorrow. And that's what we're going to do.
Okay.
All right. Let's all rise for the jury.
Folks, that's this portion for this week. We saw the ATF testify. We saw the mother of the defendant attempt to testify. Who's got a mic open? Isn't that you, Chris? Gotcha. But I've got me in studio, folks. We got Tim Williamson off of X, Freed Merc 65 on the X platform. We've got my co-host B. Wayne and Grizzly Greg in here with us. Let's take a moment and see what they think. Tim, I think I had audio problems, and I assumed you had audio problems earlier. Can you speak?
Can you hear me?
Boy, I got you now.
Okay, brother.
So I know I know my co-host has been following the case, and you've been following it as well. What's your temperature with it this far? If you were sitting on the jury and asked to decide now, where would you be?
Ooh. First, let me say I thought that was an excellent witness. The gun expert.
You thought the ATF was the best witness the state's had this far, huh?
Yes, I think so. I'm still not real comfortable with how the Smith County. We go to, was it Van Zandt County?
That's correct.
Apparently, the illegal firearm in question, was it either in view or was discovered? There was seems like to me some conversation about
what had happened. What had happened was,
thank you.
That there's a pretty large value dollar amount burglary that happened in Smith County. Smith County and Van Zandt County in Texas are two adjacent counties. They're next door to each other. Smith County is where Tyler, Texas is, one of the larger municipalities there. So they're running down. They had a burglary that involved a lot of gold coins, a lot of high dollar value items that were stolen out of a house in Smith County. Smith County gets word that their suspects could absolutely be in Van Zandt County and got an address, probably talking from Van Zandt County from what it sounds like. We did hear that a little bit of that in the testimony from the Van Zandt County detective, that the subjects there in this location were known, that they'd been handled before. So they may have told them, hey, these guys may be good for something like that. Smith County goes out. They recognize a vehicle that was named as a suspect vehicle in the burglary parked on this piece of property. When we say it's a residence, this is not like in a neighborhood. We got a driveway. Most likely it's probably 3 or 4 acres of land. It's got a trailer house and a driveway up to it. Typically, it will have a longer driveway. So they see this vehicle there and they make contact. Inside the vehicle, they see enough items that they believe to be connected to the burglary, that they've got enough from going to the residence and seeing on view these items there. And they write themselves a search warrant, notify Van Zandt County. They're running paper in their county. Van Zandt County shows up. During this search, they discover inside of a freezer a sawed-off shotgun. The one that we're talking about today was inside of a freezer. Remember, on the property, you've got a double-wide trailer and you've got a travel pull-behind trailer like a camper parked behind the residence. And I suspect that they hadn't said this, but the way they talk about them being parked, the only reasonable reason that you would do that is that you're sharing this single septic tank between the two domiciles, the trailer and the double wide. But they discovered the shotgun during running a evidentiary search warrant for items that were taken in a burglary. So that's how it lined up. That's how Smith County gets there. Smith County was the first detective or investigator interviewed. He is not the arresting agency, and his agency has no cases, and they made that very clear, has no cases against this defendant sitting in the courtroom that we're watching. Only Van Zandt County, which would be the second detective or investigator that testified, the one that actually held the shotgun up and held the rifle. That's the arresting officer, so to speak. Did that help clear it up any or make it more difficult to understand?
No, that clears it up, and that was my overall recollection of what occurred. That the Smith County detectives came across the illegal firearm, correct?
No, I believe it was the Van Zandt County.
Okay, I'm sorry. Okay.
By the time the search warrant had been signed and got there, both agencies are on site.
Okay. All right. Yeah.
And let me tell you how I know that. If I'm in another county and I need a search warrant signed, I've got to have a judge in that county sign it in that jurisdiction. And my first call is going to be to whatever agency there. Hey, you got a number to a judge. So I'm pretty sure that's how that went.
Okay. All right. Well, that clears a lot up for me.
Welcome. Happy Wednesday. It is our episode 4 of our new night court version where we're showing you a real criminal trial. This one's out of Texas over a short-barreled shotgun, a felony criminal trial. This is the 4th episode. We're going to hear the defense tonight. In fact, I'll show you guys a recap here in just a moment. But I want to remind you there's a QR code on the screen that goes to our Patreon group. All of our Patreon support member tiers as of this Friday will be eligible next Wednesday to sit on the jury and give us sit on our mock jury and give us a decision on this case that we've been watching. We'll also do a pretty strong recap on that. But with that, let's jump into the recap on the previous 3 episodes. So any of you folks that may have forgotten or the new viewers, you can catch up. Let's take a look.
We are now on record cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. And as I told you, yes, Mr. Young, if you'll please rise. Mr. Hartwell, if you will present the indictment to Mr. Young.
In the name and by the authority of the state of Texas, the grand jury for the county of Van Zandt, state of Texas, duly selected, impaneled, sworn, charged, and organized as such at the January term AD 2021 of the 294th Judicial District Court for said county, upon their oaths present in and to said court at said term, that Reginald Hoyt Young II, hereinafter styled dependent, on or about November 25th, 2020, and before the presentment of this indictment in the county and state aforesaid, did then and there intentionally or knowingly possess a short barrel firearm, to wit, an Eastern Arms 16-gauge shotgun, against the peace and dignity of the state, signed foreman of the grand jury.
Thank you, Mr. Harwell. And Mr. Young, how do you enter a plea?
Not guilty.
Not guilty?
To be really kind of blunt about this case, it's fairly straightforward. On November 25th, you'll hear evidence that deputies with Smith County Sheriff's Office was investigating another incident that happened in Smith County. You'll hear that Mr. Young was not the subject of that investigation. In fact, the subject of that investigation was a man by the name of Russell Melton. However, during the course of their investigation, the deputies with Smith County were led to the property that Mr. Young resided on. You'll hear that they found some evidence from that Smith County incident on the property. And as follow-up, they got a search warrant and searched the property, where they found a sawed-off shotgun. Good afternoon, Investigator McDonald. Can you please start by introducing yourself to the jury and spell your last name for the court reporter?
Absolutely. Tim McDonald, TIMMCDONALD.
Can you tell me what the basics of that investigation was?
Yes, we were investigating a burglary that took place in Smith County.
What was found as a result of the search warrant?
We located a firearm that was found to be a violation of Texas law.
Mr. Stevens, your witness.
Thank you, John. Investigator McDonald, I'm Bill Stevens, going to ask some questions. If I don't make myself clear, just please stop me, okay?
Yes, sir. Thank you.
All right. Now, how did you derive at the fact that Mr. Young lived at that travel trailer? Other than his statement, was there any evidence that you found that tied him to that travel trailer?
Yes.
What was that?
His vehicle parked.
His vehicle?
His vehicle was parked in the vicinity.
Okay. So because his vehicle's parked there, that means he lives there? Your investigation, he was not the target of your investigation, correct?
That's correct.
Okay.
He was not.
And to your knowledge, was he arrested for anything other than the sawed-off shotgun?
Not that I'm aware of.
Okay. What was the investigation all about that led you out to that location?
It was a burglary of a habitation that occurred in Smith County.
And what kind of property were y'all actually looking for?
We were looking for gold, coins, and other precious metals, firearms, and items that were specifically taken from that specific residence in Smith County.
All right, sir, if you'll raise your right hand, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay. And upon arrival there at that location, who did you meet with?
Met with Deputy Kevin Londoff and Deputy Tim McDonald with the Smith County Sheriff's Office.
Okay. And did they advise you of the purpose of their call and why they were at that location?
They did.
Okay. And as a result of that, what happened?
So they were there, like I said, investigating a property crime, which was a burglary. They had had a significant number of gold coins stolen out of a safe in the northwest portion of their county. And
just to take a quick look and make sure that this item is safe. Ask you to identify it, please.
okay, it is safe. This is a breakover shotgun that has been had the stock removed and the length of the barrel, or a length of the barrel.
Okay.
The barrel was sawed off with most likely a hacksaw or something to that effect. That's what it appears. It doesn't, it's not clean. It does not appear to have been professionally modified.
In measurements, what are we talking and what would you be looking at?
The barrel should be at least 18 inches long and the overall length should be 27 inches long, minimum.
No objection, Judge. No objection.
All right, there being no objection, State's Exhibit 6 is admitted.
What qualifies as a prohibited weapon? What was that number in terms
Anything
of
under
barrel
18
length?
Anything under 18 inches.
Would you please take a moment and measure the length of that barrel there?
Shows a 16th over 11 inches.
Now, my client was not charged with anything related from the burglary. Is that correct?
That's my understanding.
Okay. Lieutenant, did you take any fingerprints from the shotgun?
I did not.
You did not. Do you know if anybody took any fingerprints?
Not to my knowledge.
Okay. Did you ever see Mr. Young possess? I mean, with your eyes, did you ever see Mr. Young possess the shotgun?
No, I did not see it in his hands or on his person. So no, I did not.
Okay. Is that sawed-off shotgun operable?
So I would not consider it operable at this time. No.
Counsel also asked you about whether that sawed-off shotgun is operable. What would it take for it to be operable?
Simply sliding a firing pin into position and loading it.
How long would that take to slide that firing pin?
Just a few seconds.
Giving context to why law enforcement showed up at Mr. Young's home. And that's because they were following up leads on a burglary out of Smith County. He was not a suspect, but rather was being contacted as a potential witness to that burglary. And for that reason alone, we are referring.
Good afternoon, Agent Petrie. Can you please introduce yourself to the jury by stating your full name and spelling your last name for the court reporter?
My name is Joshua Petrie, Petree.
And can you tell me what you do for a living?
I'm a special agent with the Bureau of Alcohol, Tobacco, Firearms, and Explosives.
And Agent Petrie, I'm going to show you what's enlarged and admitted as State's Exhibit 6. Can you take a look at that item?
Yes.
Can you describe what that item is?
This is a weapon made from a shotgun. It can be classified in two different manners. Weapon made from, because lawfully to possess firearms like this, they have to be an overall length of 26 inches and or the barrel has to be at least 18 inches long because it's a shotgun. And it's obvious that this one has been shortened on both the buttstock and the barrel.
And would you classify, so that appears to be a modified shotgun?
Yes, it originated its life as a shotgun that people would fire from the shoulder, typically for hunting of birds or things of that nature.
So in your training and experience, does that appear to be a prohibited weapon?
Yes.
And is that due to the length?
Yes, these are considered concealable. Therefore, they're prohibited because they can be hidden under trench coats. The laws were originated with these weapons back in the early 30s when mobsters would carry them and Tommy guns underneath their trench coats because they're considered weapons of violence and they're readily concealable.
And Agent Petrie, can you tell me, does that shotgun appear to be readily operable right now?
It meets the definition of a firearm. I haven't actually tested it to see if it functions, but it was intended to be a weapon and it is capable of being readily converted to fire if it won't fire in this form.
And if I told you that the shotgun did not have a firing pin, could you tell me the process that it would take to
if that's the case, it's a pretty simple procedure to drop a firing pin in. This type of shotgun right here was manufactured by a J. Stevens company in the early 1900s to the 50s. They sold these types when they were in original form.
Does not having a firing pin, does that make a weapon not a firearm?
No, it just says it has to be readily converted or is intended to be fired by the means of an explosion. A firearm itself is a weapon, whether it's fired or not. It can be pointed at somebody and have the same intention. But if it's created to be a firearm, then it's a firearm. But what it does is it gives a measure of truthfulness. And when I saw him start to stammer and sputter, which is a common deceptive technique, I knew that he was probably worried about that question.
And then when you mentioned not looking to charge Mr. Young's mom, can you go into that a little bit and that exchange?
Correct. Throughout that interview, Mr. Young was trying to what I considered minimize his criminal involvement with this. He knew I was questioning him about it. So ways of doing that are to minimize what I knew or what I had, and then also try to place the blame on others. He was trying to say that his mother went and got it after he initially told me that Mr. Waddell called him. He said that Mr. Waddell, that his mother went and retrieved them and then brought them back to the house, which I informed him that is a violation of federal law because that's a prohibited weapon. And I wasn't looking to get his mother in trouble. The charge, when I used the word charge, meant get your mother in trouble. I just wanted the truth. I could tell that he was trying to deflect.
All right, does the state wish to call any additional witnesses?
No, Your Honor, state rests.
State rests its evidence at this time.
Yes, sir.
Mr. Stevens, would you like your opening statement at this time?
No opening statement, Your Honor.
So that's waived. Does the defense wish to call any witnesses?
Yes, Your Honor.
Who would you like to call?
Sheila Prater, Your Honor.
Sheila Prater?
Prater.
Prater.
Prater, yes, sir.
P-R-A.
P-R-A-T-E-R.
Thank you.
I believe that's how it's spelled, Judge.
All right, let the record reflect that the jury has been excused, that this hearing is conducted outside their presence. Court has done so on the suggestion that some of the questions may implicate the Fifth Amendment rights of the witness, Ms. Prater. And is your name Sheila Prater?
Yes.
Is it S-H-E-I-L-A?
No, L-I-A.
L-I-A, Prater's testimony that could implicate her Fifth Amendment rights.
Yes, Your Honor. I'll be asking her. We've heard testimony already that it's stated that my client put the shotgun in the travel trailer and that my client lives there. Her testimony is going to be that she is the one that put the shotgun there and that my client doesn't live there, that she did. With that being said, it's a prohibited weapon. And if she testifies that she put it there, then that could open herself up to liability. So that's my concern, Your Honor. And I did visit with Ms. Prater.
Due to the nature of the direct examination and potential cross-examination of this witness, Ms. Sheila Prater, the court finds that her Fifth Amendment rights against self-incrimination could become an issue. And so the court has found Ms. Prater to be indigent, and the court is going to appoint the Honorable Richard Schmidt to advise Ms. Prater both prior to and during her testimony regarding her Fifth Amendment rights. The court tomorrow, after she has received the advice of counsel, will also admonish her as to her Fifth Amendment right. But unfortunately, Mr. Schmidt would not be available today on such.
Okay, folks, that is a little recap for the first 3 episodes. We're going to see episode tonight. So we left off. The prosecution has rested. The state, in other words, has rested. They brought on 2 investigators from 2 different agencies. They talked about how they got to the residence where they found the shotgun. They talked about what the shotgun was. They talked about laying foundation for the possession. The elements of the offense are is that you have to possess, and ownership's not important, but whoever possesses this prohibited weapon is committing a felony in the state of Texas. So they've laid that foundation, even brought in an ATF agent who worked this case in some manner, but he worked the case to established that the firearm was actually unlawful. And the ATF agent did some sort of interrogation with the defendant and established the possession of that. He knew it, that he had it, and he was the one who was the one who would be labeled as the possessor in this case. So we're going to pick up. We also ended with the defendant's mother. The state rested. The defense picks up the case at the very end of the last episode. They bring on the defendant's mother. This is her property that the shotgun was found on. The defense's claim is that her son doesn't live there. She was out of town. He was visiting to make sure everything was right on the property, but doesn't live there. The state contains or asserts that he does live there and therefore was in possession of the entire property and its contents, including the short barrel shotgun. But there was a problem with her testimony. They didn't get on with it in the last episode. They stopped it. It's a little unusual circumstance where you have a defendant that could incriminate themselves by providing testimony on behalf of another. So the judge stopped it, and we're going to pick up today where he assigned an attorney to her. This is the following day. They've had a chance to meet with the attorney. I'm going to show you that little tidbit there as far as what admonishment and what advice that she'd received from her attorneys, from what she can testify on behalf of her son without incriminating herself. But without further ado, let's get to episode 4. I'm not sure.
We are now on record cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. And as I told you, yes, Mr. Young, if you'll please rise. Mr. Hartwell, if you the indictment to Mr. Young.
Sorry, folks. Let's see if I can get this thing to pop and load again here. There is an issue. There we go. Sorry about that.
All right, we are on record in cause number CR 21-98, State of Texas versus Reginald Hoyt Young II. This is a hearing outside the presence of the jury. Attorneys for the state, attorney for the defendant, and the defendant are present on the witness stand. At this time is Ms. Sheila Prater. Yesterday, it came to the court's attention that there would possibly be some questions asked by Mr. Stevens regarding potentially incriminating responses, depending on the response of Ms. Prater. And it was recommended by Mr. Stevens that the court consider whether or not Ms. Prater should be afforded the assistance of counsel. The court had reviewed her indigency and finds her to be indigent. The court has appointed the Honorable Richard Schmidt for the limited purpose of advising Ms. Prater regarding her questions, or regarding the questions and her answers thereto in this trial. Mr. Schmidt, at this time, if you will just, without divulging attorney-client privilege, can you just assure the court of any admonishments or statements of representation that you've made to Ms. Prater so that the court is satisfied that she understands her rights and her Fifth Amendment constitutional right against self-incrimination?
Yes, sir. After a brief review of the indictment in this case and the applicable statutes, I informed Ms. Prater of the statute of limitations as far as state charges are concerned. Statute of limitations pertaining to any federal charges that might arise from alleged conduct. No right to remain silent and against self-incrimination. How that works as a witness, as well as the potential consequences for aggravated perjury, which is making a material misstatement under oath, and those potential state consequences.
So he's given a bunch of legalese, and by the way, he's just off camera there to the right.
Thank you, Mr. Schmidt. And so, Ms. Prater, you understand that I swore you in to tell the truth yesterday, and so now you're under oath, just like you were yesterday. You understand that?
Yes.
And you've had the
folks, what the advice that she received was statute of limitations maybe is not necessarily an issue. She knows what she can testify to, what she can't testify to without putting herself in jeopardy. And so the judge is going to ask a few more instructions, a few more questions of her, and then we'll get on with her testimony.
The opportunity to talk with Mr. Schmidt, who the court has appointed as your attorney, correct?
Yes,
Do you understand that you have a right against self-incrimination?
yes,
Do you understand that any questions asked by either the defense, through Mr. Stevens, or through the state, through either their prosecuting attorneys, that if that question has a tendency to potentially incriminate you regarding your response, you understand that you have a constitutional right to not answer that?
yes,
And are you comfortable with what your discussions with Mr. Schmidt have been regarding what your rights are and the potential criminal consequences should you waive any of those rights or make any kind of statements that is incriminating to you?
yes, thank you.
Okay, and so I'm going to go forward and I'm going to allow Mr. Stevens to ask us questions, and when he's through asking you questions, you'll be passed over to the prosecutors and they'll be able to ask their questions. If during that time you feel like you need to speak with Mr. Schmidt regarding any answer that you may give to that question, what I would like for you to do is just turn and look at me and say, Judge, I would like to speak with Mr. Schmidt.
Okay.
And then we'll pause briefly. We may not excuse the jury, but I may allow Mr. Schmidt to walk up here and be able to have a conversation with him. And he can advise you during your question.
Thank you.
Okay?
Yes,
Mr. Schmidt, any objection to that procedure?
No objection to that procedure, although I would remind you that if you speak with me, do it before you answer the question.
yes,
All right. Any issue from the defense?
No, sir.
Any issues from the state?
No, sir.
Okay, we ready to bring the jury in?
Yes.
All right. So I'll rise for the jury.
Well, check out the lady in the yellow. She got no respect for that jury. Hands on her hips. She looks like she's upset at the jury coming in. And this is just a bit of procedure, folks. The jury's coming into the jury box. They haven't been present for any of the testimony they talked about with her being in jeopardy. The jury won't know that she could have had a Fifth Amendment issue.
You may be seated. All right, good morning, ladies and gentlemen of the jury. I appreciate you being here on time this morning. We are back on record in cause number CR 21-98. The jury is present and seated in the courtroom, along with the attorneys for the state, attorney for the defendant, and the defendant. I believe, ladies and gentlemen, that when we left off yesterday, I told you that we had some legal issues I needed to accomplish. We were able to get those done in your absence. And so we're going to resume with the testimony of Ms. Sheila Prater this morning. And I believe, Mr. Stevens, you had Ms. Prater on direct examination. Is that correct?
Correct, Your Honor.
All right, you may proceed at this time.
Thank you, Your Honor. Please state your name for the record and spell your last name.
Sheila Diane Prater. Prater is Prater.
All righty. And ma'am, how do you know Mr. Young?
Ray is my son.
Okay. And do y'all live together?
No,
Did y'all live together back in November of 2020?
no,
Okay. Were you
This attorney, I think,
back in November of
reads twice,
2020?
asked
Do you
once.
recall where you were?
I was in Arizona.
Okay. And what was the purpose of being in Arizona?
I had had my knees replaced and I had gone back to Arizona
Okay.
for the doctor and I was actually like living there. So
Okay. And when you were not in Arizona, but when you're back here in Texas, where do you live?
excuse me.
Where do you live in Texas here?
In Van Wheeler.
Ben Wheeler.
Yes,
Okay. And what kind of building or structure do you live in?
I live in a travel trailer.
Travel trailer.
Yes,
Okay. And how long have you lived in that travel trailer?
I bought it about 8, 9, well, probably longer than that now.
Okay.
In what, 11, 2011, I think.
Okay. Does anybody live with you?
No,
Okay. You live by yourself?
yes,
Do you have any animals or pets?
me and my babies. I got fur babies.
Okay. And when you were out of town, was your son going over to your property, taking care of the animals and whatnot?
Yes,
Okay. As far as you know, was he staying on the property, living on the property?
not that I knew of, no,
Okay. He had his own residence, did he not?
yes,
Okay. Do you recall if that was in Athens or not?
it was in Athens.
Okay. Now, do you know somebody by the name of Larry Don?
Tommy Don,
Tommy Don, I apologize.
yes, Tommy.
You know
Don.
Tommy Don?
I do.
Okay. And how do you know Tommy Don?
Tommy Don is a neighborhood guy that, he's a jack of all trades.
Okay.
And so everybody knows Tommy Don.
Okay. And Tommy John was actually arrested around your property. Is that correct?
Correct.
Okay. And after Tommy Don was arrested, okay, he had some property that he was worried about being stolen from his residence. Is that correct?
Yes.
Okay. And what was some of the property that he was worried about?
He had a TV and he had a gun,
Okay.
antique gun.
Okay. Was that a shotgun? Do you remember if it was a shotgun?
Yes, it's a shotgun.
Okay. And did you take possession of those items to keep for him while he was locked up?
Yes, I did.
Did you go to his property and get those items, or did your son bring those items to you?
I went to the property and picked them up.
Okay. And do you know if after you picked up the property, what did you do with it?
The TV is in the living room behind the chair. And I put the gun in the freezer. The freezer in my travel trailer does not work. So I just stuck it up there.
Okay. And where was the freezer located within your residence?
It's in the travel trailer. But like I said, it does not work. It's like just on the west wall.
Okay. But it's inside the travel
Yes.
trailer.
Yes.
Okay. Did you ever ask your son to pick up the guns, handle the guns, bring them to you or anything like that?
No.
Okay. And so you're telling this jury that you're the one that picked up the shotgun and the TV and took to your property.
That's what I'm saying.
Okay. And do you know any idea about how long you'd had that shotgun?
Tom John was doing some work for me, and I think he started doing that around September.
Ma'am, would that be
As best as I can remember.
September of 2020?
Right, as
Okay.
best as I can remember, it was late August. I'm thinking it was late August, early September. And this incident happened in November.
Right.
So like, what, 3-4 months,
Okay.
somewhere like that.
What kind of work was he doing on your property?
He was tearing down my grandparents' house.
Okay.
And so,
And were you there when the police came to arrest him?
I was.
Okay. Did he ask you to get that property?
Your Honor, objection leading.
Sustained.
Did Tommy Don ask you to go get that property?
Objection leading.
Judges.
Calls for hearsay.
Hearsay?
Yes.
Sustained.
You did not go get that property at the direction of your son, did you?
No.
Okay.
No.
Do you know if your son ever handled that shotgun or not?
Not that I know of.
Okay. I'll pass the witness, Your Honor.
Mr. Hernandez, your witness.
Thank you, Your Honor. Good morning, Ms. Prater.
Good morning.
Let's just start there. The question that counsel just asked you was if you knew if your son ever handled that gun. Is that the shotgun you're talking about?
Is okay. Okay. I'm not exactly sure what you're asking me.
Okay, let me clarify. I appreciate you asking me to do that. You just answered the question, did your son ever handle that gun? And you said no. Which gun are you referring to?
We're talking about the gun that's in question, correct?
Well, that's what I want to know. Which gun are you referring to?
How many guns are we talking about? I'm confused. I apologize, but
Let me ask you about the shotgun.
okay. Ask me about the shotgun.
Okay, the sawed-off shotgun.
Yes.
Okay. Counsel just asked you if you knew if he ever handled it, and you said, not that I know of.
No,
Is your answer now no, or is it not that you know of?
not. I cannot say what someone did, not that I know of.
Okay.
Yes, that's my answer.
So he could have handled that weapon, and you would not have been aware of that. True?
I can't see people when I'm not there, so
Exactly.
that's correct.
Okay. So if there had been testimony here where, well, let's back up. Do you see your son here in the courtroom today?
Yeah, I do.
Okay. And can you just tell the court where he's seated?
He's sitting right there.
All right. So you see him. That's Ray, I believe you spoke with. You mentioned Ray.
I call him Ray.
Okay, but he goes by Reginald. Is that his first?
His first name is Reginald.
Okay.
I call him Ray.
Okay. So let's get into the piece about the weapon. You were confused as to which gun we were talking about.
Well,
How many guns did you have on that property?
well, I mean, you're the one that said which gun. So like, I'm trying to like, is there any other gun that we're talking about that I don't know about? Because I only know about the one gun.
Your Honor, may I approach the witness?
You may.
Yes.
Spraker, this has been identified as State's Exhibit 7. Do you recognize this weapon?
I ain't never seen that in my life.
Never seen it in your life. Okay.
No.
And if,
Whose is it?
well, if your son testified that he shot this gun while living on your property, was he lying?
Sir, I don't know what gun. I don't even know anything about that gun.
You don't.
I'm sorry.
Okay. Well, if I were to tell you that there's been testimony that your son told law enforcement that he asked you, or he went out and picked up sawed-off shotgun and the rifle and brought it back to your property, is that a lie?
Sir, I don't know anything about that gun.
So you don't know if he shot it or not.
Sir, I don't know. I don't have a clue. I don't know anything about that gun.
So he could have shot it then.
Sir, anything can happen. I don't know anything about that gun.
Okay.
Now, this gun I know about.
Can we talk about your property there, ma'am?
If you like.
Please. How many mobile home or travel trailers are on that property?
2.
2.
Yes.
Okay. And how would you describe the one you live in?
It's a 5th wheel. Got a bedroom, kitchen, living room.
Okay, all right. And what about that second? Is it more of an RV or is it a
No,
trailer?
the other one, was my mom's.
Okay.
So it was a double wide.
Okay, double wide.
Yes.
And do you know Tommy Don's last name,
I
ma'am?
do not.
You don't, okay. Waddell, does that sound familiar?
I don't know.
Okay, all right. So this morning you testified that you actually moved that sawed-off shotgun. If I may approach, Your Honor?
You may.
You testified that you moved this sawed-off shotgun
Yes, sir.
and placed it in
The freezer.
the freezer.
Yes, sir.
And where was that freezer located again?
In my RV.
In your RV. And you
Yes.
testified that that RV, that it was in the freezer and that freezer was inside your RV.
Yes.
All right. I'm showing you what's been marked as State's Exhibit 1. Do you recognize that, ma'am?
Yeah.
What is that?
This is refrigerator and this was an outside freezer.
Outside freezer.
Yeah,
Okay. And where's that freezer located on your property?
it's in the back.
Okay. And it looks to be that there's a trailer or a mobile home behind it. What is that?
Yes,
Is that the one you lived in?
yes,
So there's a refrigerator to the right and then the freezer is center on State's Exhibit 1. Is that correct?
right.
And you've testified that when you moved that sawed-off shotgun, you put it inside the freezer in your RV.
Yes.
And that freezer is not in your RV in State's Exhibit 1, is it?
No, it's not.
So if your son had told law enforcement that he moved that shotgun and that rifle from an automobile and put the shotgun, the sawed-off shotgun, in that freezer, is he telling the truth or is he lying?
So I don't know.
You weren't there all the time, 100% of the time.
No,
Fair.
I was not.
I may approach you, Your Honor.
Yes, sir. You may.
Ms. Prater, I'm showing you now a photograph that's been identified as State's Exhibit 3.
Okay.
Do you recognize that?
Yes.
What is it?
Freezer.
That's the freezer.
Yeah.
How about State's Exhibit 4 and 5? What is that?
That's that gun you just showed me.
And where is that located?
It's on the bench
And where is that bench located?
in the house,
Which house?
in mine.
That's your house.
Yeah.
I have no further questions, Your Honor. Ask the witness.
Mr. Stevens, you're with us.
Yes, Your Honor. Ms. Prater, when you picked up the shotgun to put it at your property for safekeeping, Did
Yes.
you know that it was an illegal prohibited weapon?
Had no idea.
Have you ever shot a gun?
No.
Never shot a gun.
City girl.
So you're not familiar with firearms at all.
Not at all.
It's your testimony that you are the one that picked up the shotgun and put it in on your property, correct?
Yes.
Pass witness, right?
Mr. Hernandez.
Ms. Prater, you weren't home on November 25th, 2020, were you?
No, sir, I wasn't.
And where were you on that date?
I was in Phoenix,
Pardon me?
Phoenix, Arizona.
Phoenix, Arizona. Okay. When did that surgery take place?
Oh, I had several. So starting in 19 till 20.
But November 25th, you were in Phoenix.
Yes.
And your son, the defendant, was taking care of your property that day, was he not?
Yes.
And did you know who he was dating back then on November 25th, 2020?
Heather.
Heather. And to your knowledge, was Heather there that day as well?
I have no idea.
You don't know. Okay.
But if Ray was there, I would assume so, but I
Okay.
wasn't there, so I don't know.
Okay. So you weren't there, and I just showed you States Exhibits 4 and 5 showing that rifle. And it's inside your RV, is it not?
Yeah.
And you were in Phoenix, so you have no idea how that would have been put inside that
No.
RV. And it's your testimony that that shotgun was placed in the refrigerator inside your RV.
That's where I put it.
So the freezer that I showed you in States Exhibit 4, that's not the one you're talking about, is it?
No, it's not.
So logically, it would make sense that somebody pulled it out of your refrigerator and put it outside in the freezer.
Logically speaking, I mean, hey, we can't go against logic. It didn't walk out there. So, yeah, somebody had to take it.
No further questions, Your Honor. I pass the witness.
Mr. Stevens.
No further questions, Your Honor.
Any objection to Ms. Prater being finally excused?
No, Your Honor.
No, Your Honor.
All right, Ms. Prater, you're free to go. What's your step? The question or an issue? Okay.
Okay, folks, before we get into the closing arguments, that was the defense's only witness. The defense rested after the conclusion of her testimony. I cut out the way this court does it. They actually read the jury's charge before the closing arguments. A lot of courts do that. I think the last thing that the parties want is their last final thoughts in the jury's mind versus the judge's instructions. But I will replay that next week when we seat our mock grand jury, our Patreon members. I think I've got room for almost every one of us to be on the jury next week. But I'll replay the jury's charge next week, so you'll have the exact same instructions that the real jury had. And I'm going to say it again. All the folks that are Patreon support tier members, in the QR code in the top left-hand corner will get you there. All persons that are paid or support tier members on our Patreon will be eligible to sit on the jury next week and decide this case as the real jury did. But we're going to hear the closing arguments from the state and the defense. Let's get back to it.
All right, at this time, the state will be permitted to give the first closing statement. Mr. Hernandez, are you
Yes.
doing that?
Yes, Your
All
Honor.
right, you may proceed, sir.
Thank you very much.
Do you need a podium, sir?
No, sir, I do not. Thank you.
Okay, please support Mr. Stevens. Thank you very much, ladies and gentlemen, for your attention to this matter. This is the last time we'll get to address you directly, and then you'll be given the opportunity to go into deliberations, go through the evidence. I'd like to start off by pointing out in the instructions on page 5, possession. Possession means actual care, custody, control, or management. I'd like to point out possession for you. I'm now possessing it, caring for it. It's under my control, under my management. I'm still possessing it, right? That was 6 steps that it took. I knew it was there. Possession. That is an Eastern Arms 16 gauge shotgun. As ATF agent Petrie testified, it's a rather old shotgun, but it's post 1890s. He says it was probably early 1900s. So the exceptions as a curio or as a relic don't apply. This is a prohibited weapon by all accounts and definitions and should not be in public. He told you the very reason for it, or at least one of the considerations, was it's something that can be used for a lot of people. Placed underneath a trench coat, placed inside a coat. There are reasons for that. Also, got into specifics, the definition of that. You recall, it needs to be a barrel length less than 18 inches. Investigator Keltner testified that barrel length was 11 inches. That means somebody took off at least 7 inches off that barrel, making it an illegal weapon. And by all accounts, the full length, Investigator Keltner testified, was 19.5 inches. At a minimum, it should be 26. There are very good reasons in history why those things shouldn't be out. You've heard during the testimony that Mr. Young, in conversation with Agent Petrie and Investigator Keltner, admitted by his own words to going over to Mr. Waddell's property to get those 2 firearms, get the rifle, get the shotgun. That was possession, and he brought it back to that property. You also heard him admit in that conversation that he shot that rifle. Oh yeah, I shot the rifle. Shot dogs. I did that. Does it stand to reason that he didn't know about that shotgun? Heard the statement or the phrase "in for a penny, in for a pound," right? If you're admitting to, yeah, I knew about the rifle, but didn't know about the shotgun. That's not logical. And if we go into that logic piece, when Ms. Prater testified, that she is the one who went out and picked up that illegal weapon and a TV and brought it back to her home. And she placed it inside her home, in the freezer inside her home. But lo and behold, you've seen States Exhibits 4 and 5. Let me clarify that. States Exhibits 2 and 3. The interior of a freezer. Not working. But where was that freezer located? Outside. Not inside, as Ms. Prater testified. Reminds me of that story about if you're walking down a country road and you're noticing all the fence posts on your right side, and you come upon a turtle popped up on top of that post. That turtle logically climbed itself up that wood, propped itself on that pole, or did somebody put it there? I submit to you, somebody put it there. That's what logic would tell you. Nothing magical happened. Gravity didn't fail to exist, and the turtle floated up and lightly tapped down on that post. Somebody put it there. Submit to you that President Young went and grabbed that shotgun, went and grabbed that rifle and put them there. The other photograph showing the rifle is inside in the living area of that trailer. States Exhibit 5 and 4. Ms. Prater readily testified and said, yes, that's the inside of my trailer. That's where I live. I've never seen that before. To her credit, she wasn't there on the 25th. I submit to you that those weapons were there for a while. She brought them over and utilized them. By definition, that is a prohibited weapon. It's easy, I've pointed out to you in terms of the 11 inches, the less than 26 inches. And by all accounts, are you going to believe what Mr. Young told you through that interview with Investigator Petrie, Agent Petrie and Investigator Kellner? He knew about the guns, he had fired the rifle. Or are we going to rely on Ms. Prater's testimony that she was responsible for moving those weapons over, but yet she doesn't know what happened on November 25th, 2020, Van Zandt County, state of Texas. Every bit of evidence points to the day we were, Mr. Young, and I'd ask you to return that. Thank you.
May please the court, counsel. Good morning, ladies and gentlemen. Again, I want to thank y'all for being here. Y'all are serving a very, very important function, important duty for our society as it is. So I do want to thank each and one of y'all for being here. I want to point out that my client chose not to testify. It's his Fifth Amendment right, just like it's each of y'all's Fifth Amendment right to not testify if you were ever in his position. So you cannot hold that against him, ladies and gentlemen, that he did not testify. Let's don't get confused with the shotgun and the rifle. I believe the rifle's coming up to be kind of a scare tactic, so to speak. The issue is about the shotgun. It's not about the rifle. It doesn't matter if my client had fired the rifle or not. The issue is the shotgun. You know, we did hear from Ms. Prater. She had no reason to get up here and lie. I realize she's testifying to help her son. However, she has no reason to get up here and lie, ladies and gentlemen, because she has perhaps put herself in a position of compromise. I could very well file a case against Ms. Prater because of her testimony about stating that she is the one that handled the firearm, not her son. So she had a lot on the line when she got up and testified, ladies and gentlemen. And, you know, if y'all listen back to the recording from Agent Petrie, if you recall, my client at the very beginning said he did not put the shotgun in the freezer, that his mom did. And then after they talk a little bit more, Petrie basically, in a way, threatened my client, hey, you better tell the truth, okay? And then at that time, he says, well, yeah, I did it. He didn't want to get his mom in trouble. That's obvious. You know, he loves his mom. He doesn't want his mom to get in trouble for anything. So, okay, I did it. That's what he said. And ladies and gentlemen, a lot's being made about this possession, as well as it should be, you know. And if you ladies and gentlemen will look at when y'all get the instructions again, look at where it says about possession, ladies and gentlemen. Care, custody, control, and management. I disagree with the prosecutor when he grabbed the shotgun a while ago and then laid it back down. He said he still possessed it. I guess if I go touch it, then I'll possess it. Doesn't make sense, ladies and gentlemen, okay? My client did not live at that location, period. His mom testified he lived in Athens. If my client had gone to get the shotgun and the TV, why would he have taken it to his mom's trailer? Why wouldn't he have taken it home to his house in Athens? Just doesn't make sense, ladies and gentlemen. And if you look at the shotgun, I mean, I realize under the definition of the law, it might be a prohibited weapon, but it's more of a relic than anything else. And if somebody grabbed it, it's not operable. You can't even fire the thing. Now, we've heard talk about, oh, you could put a firing pin in it. Yeah, if somebody knows what they're doing. But come on, it's not, it's more of a relic or an antique than anything else, ladies and gentlemen. And also, ladies and gentlemen, kind of show the fact that my client didn't live at that location. When the deputies came from Smith County, they were investigating a burglary that happened in Smith County. Some of their investigations led them to this location. When they get there, my client's asleep in his truck or his car. If that's his home, why wouldn't he be inside the mobile home or the travel trailer sleep? Why would he sleep in his vehicle? He would have been in the house. He didn't live there, ladies and gentlemen. He did not live there. His mom lived there. He was merely going over there to take care of the animals and whatnot when his mom was out of town. I'm sure mom doesn't know, but I'm sure he was going back and forth and basically on a daily basis taking care of the property. Ladies and gentlemen, there is reasonable doubt in this case. Absolutely. There's reasonable doubt as to who put the shotgun in the freezer. Let's just say my client did put the shotgun in the freezer for a moment. Okay. He doesn't live there. He doesn't have care of control of it once he left that building. No. But he didn't put it there, ladies and gentlemen. His mom did. And she put her neck on the line when she got up here and testified. And she testified to the truth, ladies and gentlemen. She did. You can look at her demeanor. She wasn't combative and, she was confused about the 22. She wasn't familiar with the 22. She's not familiar with any weapons for that matter. She never fired a gun, period. So, ladies and gentlemen, I'm going to ask you to find my client not guilty. Again, listen to the video. Listen for the reason why my client changed his story to the agent. Check that out. And again, ladies and gentlemen, my client did not have care, custody, control, or management of that weapon. Again, thank y'all for your close attention to this case, and I really do appreciate y'all being here.
Thank you, Mr. Stevens. Mr. Harwell.
Thank you, Your Honor. Morning, ladies and gentlemen. So I want to start by just addressing a couple of things that Mr. Stevens brought up. The first being whether if he had grabbed the shotgun, whether he would be in possession of it too. And under the law, yes. Actually, everybody who has the ability to control, manage, or take custody of that shotgun is in possession. Possession is not limited to one person. Multiple people can be in possession of the same thing. If any of you have spouses or significant others, own a car together, you're both in possession of the car because you both have the ability to manage it, control it, take custody of it. So I submit to you that, yeah, more than one person can be in possession of the same thing at the same time. Next, I want to talk about Ms. Prater's testimony. Mr. Hernandez asked several times, your testimony today is that you put the shotgun in the fridge inside the RV. Yes. Not in the freezer outside. No. So how did it get there? Somebody must have moved it. Not Ms. Prater. She testified to that. She told you unequivocally that she did not move that shotgun to the freezer. Logically, somebody had to have. And next I want to address Agent Petrie's. You heard his testimony that he had no interest in charging Miss Prater. And you heard it during the conversation. Look, I know your mom's not a bad person, and I have no interest in charging her. I only want the truth. You heard his testimony, you heard him. He had no interest. Is he waiting out in the hallway to arrest her? I highly doubt it, even with sworn testimony. So I want to talk more about the evidence in the case. So on or about November 25th of 2020, we know that that was the date that Mr. Young was arrested for this offense. We don't know exactly what day he moved that shotgun around, but that's why the law allows for on or about. We know that he did it. Could have been on the 25th, could have been within a few days of the 25th. And we know that he was managing that property. The testimony today was that Mr. Young was taking care of the property. Well, what is taking care of if it's not managing? And he did, in fact, know that the shotgun was there. You heard in that conversation, he knew quite a bit about the shotgun. Told you that he had a cousin inspect the shotgun. So he knew it was there. You also heard in that conversation that, yeah, he did, in fact, go and pick up that shotgun. Once Agent Petrie told him, look, I'm not after charging your mom, I just want the truth. Yeah, I went, I picked up the shotgun and the 22. You heard testimony that it was in Van Zandt County. That's undisputed here. It's in properties in Ben Wheeler. This is in Van Zandt County. Everybody agrees that Mr. Young is the person in question. There is no question as to who we're dealing with here. And so I want to go into a little bit more about the intentionally and knowingly. So you heard about the firing pin. You also heard just how easy it is to slip a firing pin in. You heard Agent Petrie talk about just how many firing pins there are and how readily available they would be to get to make that shotgun fully operational in a matter of moments. You heard Agent Petrie talk about why it's important for this law. He told you how the law came about with mobsters hiding them under trench coats, how they're easily one-handed weapons that can be hidden from anybody. And he also talked about the fact that the nature of a weapon doesn't change with or without a shot, with or without a firing pin. If that shotgun was pointed at you, I doubt that any of you would think, does that have a firing pin? Still a weapon. And that's why it doesn't matter whether the firing pin is in it or not. It is still a weapon by the very nature that it is designed to expel a projectile. You heard Agent Petrie talk about the fact that it's not an antique. That fires a shotgun shell, a 16 gauge shotgun shell. He told you that a antique weapon is a black powder rifle, a muzzleloader. For those of you not familiar, that's a single shot, like you see in Civil War or Revolutionary War, that long process of pouring powder down the barrel, putting the slug in. That's an antique weapon, not that. And I want to talk a little bit about this 22 and why it's important. It's important because it corroborates everything else. Because you heard in the conversation, Mr. Young talked about, yeah, I fired the 22. If there were dogs getting into the trash, I'd have to shoot at them, have to get rid of varmints, shoot it just for fun. We live in the countryside. Hey, nobody can blame you. I mean, 22s are fun to plink with. Anybody who's ever gone out plinking with a 22 knows that, hey, quick way to blow off a little bit of stress, right? So why is it corroboration? Well, because he told you that the 22 and that sawed-off shotgun were together. So it's further indication that he did know about the sawed-off shotgun. When Agent Petrie asks about his fingerprints, that's when he starts to hesitate, because you'll notice that in that conversation, Mr. Young was only concerned about that shotgun. From the very beginning, how can I be charged with a weapon without a firing pin? It's the only thing he was concerned about. So he equivocated. I don't think my fingerprints are going to be on that shotgun. I highly doubt they'd be on that shotgun, but he can't give a definite answer because he's hoping that they're not on the shotgun. But he can't say that they're not because he knows that he did in fact move that shotgun. That's why he couldn't give a definite answer. And yeah, you heard from Agent Petrie, who told you that, yeah, with a gun like that, wood grain, some rust on it, there's nothing for a latent print to stick to. So yeah, we could not have pulled a fingerprint from that if we tried. Next, I want to talk about a specific thing in the indictment, and that's that this is an Eastern Arms shotgun, a 16 gauge. Well, you've heard testimony that this isn't in fact a 16 gauge. You heard that in that conversation. And I want to point out to you, it's extremely faint, but Eastern Arms, you probably can't see it from there. I'd be surprised if you could. It is extremely faint, but Eastern Arms is written on the side of this firearm. So this is in fact an Eastern Arms 16 gauge shotgun. Ladies and gentlemen, during Verdire, Ms. Curry talked to you about the law in this case. Talked to you about firearms. Talked to you about whether, if you believe the evidence, whether you could convict. And each of you, by your answers, indicated that you could. If you believe this evidence, you indicated that you could convict. And then the judge puts you under oath to uphold the law. Ladies and gentlemen, what I'm asking you is to hold you to your oath. That if you believe this evidence, which is clear, that you convict Mr. Young of this offense. Because on or about November 25th, 2020 in Van Zandt County, Reginald Hoyt Young II did in fact possess a prohibited weapon. Thank you.
All right, folks, that's your closing arguments. That's the entire case. You've heard the state side. You've heard the cross-examination on each other's witnesses, the state and the defense. We've seen the evidence. We've heard the closing arguments as far as what the state's contention of this offense is and what the defense's defense is. We've heard it. We've heard all of it. And we've got Tim, Fred Merck, 65 on X. He is one of our Patreon members, and I'm pretty sure he's going to make the jury next week. So
An incarcerated individual's use of institutional telephones constitutes consent, and your calls may be provided to law enforcement agencies. Thank you for using Securus.